My name's Mike Gill. Grew up my whole life in the state of New Hampshire. You know who I was? Was that guy in school. Remember the bullies? I was the guy that kicked their ass. What did you think I was going to look like? Do I look a little brash? Do I look this? How do you think I was supposed to come and look like? So maybe I don't come off as well. Because I'm embroiled in war constantly. This is what a warrior has to look like. I'm going to let you know that I'm still fighting the fight. You're going to read a letter that the judge refused me to read to the jurors. So you're going to hear this letter. You're going to hear the letter my daughter wrote me 2 days after I left, that I wouldn't see anymore. I want you to go through this trial with me. And I'm going to point out to you, and you're going to see what happens in the corrupt courtroom in New Hampshire, and the players that I have pointed out, and the importance of these players on getting caught. What do? I'm telling you we caught them. I'm telling you I'm prepared to take this as far as you will go with me. We'll clean this state up. We'll throw those people out of the courtroom. You're going to see the president of the New England Bar Association, the past president, John Ross, and you're going to see Judge McHugh. You're going to see corruption, forgery, upfront and personal. When this is done, there'll be no question in your mind of their guilt, which is what my plan was, which is why I had it on camera. These are the people. These are the representatives. This is the organization that come from, that robbed the people of FRM, took their money at the end of their lives, the money that they saved all their lives to live in dignity. These are people we elected. These are presidents of bar associations. It's immoral. These are the judge that goes in front of divorce courts and take children away. In my case, for simply greed, because I had millions, that put my children at risk without a second thought. Now, there's no justice in the courtroom if that's corrupt. Are you okay with not having justice there? I'm not. Are you okay with senators and governors who know these issues, were involved in these issues, or are part of these issues? You're going to see the president of the Bar Association of New England. I don't have a law degree. I'm not a lawyer. What you're going to see, I did for the first time. They were trained professionals trying to get it so that you don't know what happened. Limiting the scope of this trial so it's only about a number. Because they only want you to hear about numbers. They want a number? Let's give them a number. You want to keep it just to a number? I get it. My number's 5. 5 for every one of my children. I'm not fighting just for mine. My children got much older during the process. My little girl's going to be 20 next month. But I don't want them to get away with it. And I don't want it to continue to happen to other families. So, I am asking you to look at this. It's important. It's important to all of us. And then you tell me what you see. And if you see what I'm telling you, I'm asking you to directly to stand up. Let's do something. Let's get them out of here. I know how to do it, but I do need help. Please, watch this video.
You decided custody cases for money. People at their most vulnerable and desperate. You sold your judgment on the most precious thing in their lives. That kind of corruption is unspeakable.
Just before jury selection, Attorney Hilliard stood up and brought to the attention of Judge McHugh the fact that I have Mr. McHugh on my signs. I then stood up and said, Judge McHugh, you know that I think you're corrupt, and I do say it on my signs, and I'm asking you permission to let the jury know my opinion about your being corrupt. Jury selection is now over. What you didn't get to see was Judge McHugh's instructions to the jurors. And that was, if you went through a divorce and it was contentious, you can dismiss yourself or accuse yourself. Well, you think about that. Half of us been through a divorce. How many of them were pretty? They just eliminated everybody that would have been sympathetic to the situation.
I guess I should also mention to you a potential reason for not serving is if you have been involved in a contentious divorce case, which...
Why is that, Your Honor?
Pardon?
Why is that excluded?
Because I won't get into particulars, but this young lady indicated that she was involved in a similar situation which made her feel that she was not...
Half of us have been.
I don't know. But again...
But that's exactly the juror that I'm looking for, someone who has gone through the same experience. So we're going to exclude that?
Let me make the calls. That's what I do.
May we approach the bench?
Sure.
Thank you.
Much sure. And remember, she indicated she couldn't be fair because of what happened to her in the first divorce. You don't want that person in the jury, okay?
Exactly the person I want. Do I disagree
So you want unfair jurors?
I want 50% of the people in this country has gone through divorce. More than that have children. So those are exactly the people I want.
Even though they don't feel they can be fair.
I think they will be fair.
I made some prior rulings in some of your cases, that's true.
Well, it's my opinion that you are working with them.
That's okay.
Okay. It's okay for me to tell the jury that?
No, you can't do that. That's what appeals are for.
Well, I know about those.
May it please the court, and Mr. Gill, and members of the jury, my name again is Russ Hilliard. I represent the plaintiff in this lawsuit, Wiggin Nourie. With me here today is John Ross. He is a lawyer. He's been practicing law in New Hampshire for more than 45 years, and he is highly regarded in the evidence will show as a divorce attorney. Now, I also expect the evidence to show the following. Mr. Gill, the defendant, hired Wiggin Nourie and Attorney Ross in 2007 to represent him in his divorce proceeding. When he did that, that was August of 2007, when he did that, he agreed to pay for their services. And he signed an engagement letter that the firm provided to him, which set forth the terms of that engagement, the terms of the service, rates of payment, and dates of payment. You will have that letter as Exhibit 1. After August of 2007, the lawyers at Wiggin Nourie who were working on Mr. Gill's divorce case devoted many hours to working on that case. All of their work was done at his direction and at his request, with his authority and with his knowledge. You will come to learn that he demanded a very aggressive approach to his divorce case, and that approach required a lot of time and effort on the part of the lawyers of Wiggin Nourie. Each month, the law firm will send him a detailed bill itemizing all of the work they have done, what they did, what they did, how long it took them, and those will be mailed to him on a monthly basis after the month of work was completed. You will have all of those bills as Exhibit 2. What you will learn is that firm sent him bills for August, September, October, November, December of 2007, January, February, and March of 2008, and those bills were paid by Mr. Gill without any objections, questions. The firm continued to work on his divorce case. That spring, the firm, Wiggin Nourie, sent him a bill sometime early to mid-May for the work he had done in April, over 5 months' work. He didn't pay that bill immediately. The firm was continuing to work every day in May on his divorce, and you'll see itemized activities. And then in late May, Mr. Gill fired the Wiggin Nourie firm. The client can fire a lawyer anytime. But he fired them in late May, and when they then sent a bill for the remaining work they'd done in May, he hadn't paid the bill for the work they did in April. And then he didn't pay the bill for the work they did in May. Still, no objections or questions about the bill. He paid all the other bills, didn't pay the last two. In May of 2008, which is when he fired the Wiggin Nourie firm, he hired a new law firm. In fact, two new law firms. He ended up discharging them as well. And there were a couple of other firms that he hired that came and went as well. Bear in mind that he fired Wiggin Nourie in May of 2008. His divorce case went on for another 4 years after that. And finally concluded in March of 2012. But you'll hear there were a number of law firms in him. You will also have Exhibit 3. You may have seen one of these, I don't know, but the court maintains an index that shows every motion, objection, pleading, court order, whatever it is, chronologically, which will show you the activity of the divorce case in the court's record, and that will be Exhibit 3. The two bills that he didn't pay at the end for work in April and May total $117,800. $117,800. Wiggin Nourie brought suit to collect that money from Mr. Gill in May of 2011. Until the lawsuit was brought, there were no questions or objections raised with Mr. Gill to the bills. He just didn't pay the last two. I respectfully submit to you that the evidence you will hear will demonstrate that those bills for the work that was performed at his request are reasonable, and he should pay them. He has no valid defense to not paying for them, and at the end of the evidence, I will have a chance to sum up our case for you. At that time, I will ask you to enter a verdict against him for $117,800. Thank you for your time.
Thanks, Mr. Gill. Mr. Gill.
My name is Michael Gill. This goes back 7 years. I want to make this just about the bill. I want you to know I have made hundreds of millions of dollars, quite literally. I'm not here for money, not at all. I'm here. Did you see that little girl? That's my daughter. I have 5 children, 4 sons and my daughter. I haven't seen that girl in 7 years. Let me read you the letter my daughter gave me on my birthday upon which I had to leave 2 days later.
Mr. Gill, let me stop you here. This is part of the...
I want you to see that before Mr. Hilliard could even object, Judge McHugh stopped me in regards to reading the letter, my daughter's letter to me. I want you to take a second and listen to what my daughter thought of her father. On a brisk January morning, a beautiful baby boy is born to 2 deserving parents. This baby becomes a toddler and now has the company of a baby sister. As the family grows, this boy builds himself to be a competitive and hardworking child. He becomes an older brother to a boy and another sister. His reputation at school develops quick as he becomes someone who protects the underdog. He realizes young that you have to believe in yourself in order to accomplish anything. His life at home is another world. He was a brother that made life fun for his siblings, playing tricks, games nonstop. He gradually became a man himself, using the concepts he's learned before. He entered himself in the world of business, and he knew this was his place for him. He started with a single fish market and wound up at the end with a chain of successful mortgage companies. He became a father, one by one, to 5 brown-haired babies. He let each one of them grow uniquely, giving them the lessons and life skills they would need in their lives. He gave them the freedom to find what they were meant to do in life, no matter what it was. The children always knew they had a father like no one other, someone who stood up for the little guys, and someone who took the hard road in life and made something for himself. This man was a hero in every one of his loved one's eyes, especially his daughter. I love you so much, Dad. Mariah.
The subject matter of the divorce court, which is handling your divorce court, has been pointed out for several years. This has nothing to do with the amount of the bill, whether or not you owe it.
Well, this bill has to do with 5 children. My credit's perfect. I have never been late on bills, ever. This is about what a little girl thought about her father on leaving.
I'm going to have to, again...
You don't want them to hear what my daughter thought of her father?
No.
The little girl that I haven't seen for 7 years.
Sir, that's part of your divorce issue, not part of what they're being asked at this time.
Well, if you look at the bill, I want you to focus on the numbers. This isn't about numbers, it's about children. My children. I was close to all of my children. My wife is a borderline personality disorder. What you have to realize is there's no empathy.
Again, these issues were part of the divorce issue.
Well, it's recorded on the bill. So if you look at the bill, the first part of the bill, from the beginning to the end, it's about getting my wife's medical records. Except for all this money, $400,000 over on one side, $400,000, meaning we were just between $800 and $1 million. To do what now? Over 8-9 months. To get my wife's therapist records. They fought us. They spent their $500,000 not giving them to us. What do you think might be in those? I spent my half getting them. That's what you would have found. There's no argument here. Look at the bills. Except for we didn't get them. When we ordered to get them, which is the last decision that judge made on this case, they were destroyed. Are you ready? In July. By fire, by flood, by accidental shredding. They couldn't even get the examples of why they got destroyed. I know why they didn't get destroyed. Attorney Ronnie Wise had them. She committed fraud on the court. She couldn't continue to commit fraud on the court, which is why they left. And then you'll see Mr. Tober comes in, which just happens to be his best friend.
Mr. Gill, just a minute. I know that some of the bills contain references to these medical records.
Yeah, absolutely.
Okay. And
All the bill.
okay. And in terms of what you were charged and what efforts you made to get them, that may be relevant to the issues here.
Well, I think it is.
Okay, but not the specifics, not the findings of therapists, not determinations made about your children. So
Well,
if
with
you...
the therapist in the court ordered therapist that said that my wife should never see her son again. Her response was, I think it's funny.
I'm going to ask you to disregard that. Sir, stay within the 4 corners of the bill. If the bill reflects
And what we did was we went through a series of eliminating everything but the bill. I promise you this gets better. But it's important you understand what Attorney Hilliard just represented. He basically broke down the facts of the case to be, one, an employment agreement, which was forged, and secondly, the bill itself, which was based on fraud. What you didn't get to hear, all the other counts, as such as the destruction of Broussard's records, the depositions, all those things that would have put them in jail, McHugh cut out. This is the beginning of the fraud in the courtroom. So you can't hear the truth. But let's read the bill. It is a therapist record. We did spend that much money. And you know the other piece of the money that was spent on Mr. Tober is he had to go in and replace Miss Wise. You know what he replaced for you and Mr. Tober's best friend in the world is? Right there. And that's how they play catch. We had to get past the statute of limitations. They brought up that I had more attorneys. You're right. They worked with them. You know what my divorce cost me? $5 million. Because we had to get past statute of limitations. You know how many depositions we had after Mr. Ross? None till the last week. They couldn't. Statute of limitations. Do you know they all got off through statute of limitations? Do you know where that decision was made? Right here. With that judge right there. The judge in Hilliard does not want the jurors to know that it was McHugh himself that threw all these people out. It is part of the cover-up.
Your Honor, I move to strike everything he said.
I'm going to have to do that. Obviously, we make pretrial rulings, which the counsel and parties have to abide by. There's an appellate process. If I make a mistake, I'm corrected by way of appeal. But you can't bring up these issues now, sir.
I'm bringing up the issues that are read in the bill. It's the only points of interest they fought. Protect his friend to come in, destruction of my therapist records. What else was there? That's $1 million. And it went on for all those years. And they all got authorized through statutes of limitations. How many days? 3. But I couldn't file statutes. You were supposed to determine the time you should have known. We had a hearing that shows all the cover-up of people lying to me. The fact that McHugh made that decision, and we have a copy of that hearing, was criminal. It was involved in the court.
Ladies and gentlemen, again, the statute of limitations is a legal issue which I've already decided, so you can't consider it an issue.
In this court. So, it gets down to the bill. Did you see all those attorneys that are coming in? Those are people that work for me that I paid for. Did you notice I have no attorney? Mr. Hilliard is the president of the Bar Association of New England. And you know who was the past president? The guy sitting next to him.
Again, these
And
are
then there's
other
the-
issues for you. Let's try to focus on what the others are going to be.
I am focusing on that. You said I was representing myself. I'd like them to know who they are.
You can question Mr. Rosby. That's fine.
Didn't they just say I own works back? Is it okay for me to point out that he's a lawyer?
I guess they know that.
Well, did they know he was the president of the New England Bar Association? That's how important this decision is. I'm not here for my children. That's 7 years ago. I'm here for everybody else's. People who know who I am know that I'm an advocate about this. Nobody would represent, no one would fight these guys. Do you think I wouldn't want a lawyer? I hate being in this courtroom more than anybody here. But those were my kids, and they're still my kids. And I'm making a statement for them and everybody else who goes through this, that they can't keep doing this. They can't alienate our children. That letter that they didn't let us read, it's on the internet. You read it.
Obviously, and I think I told you when you first came in, the internet is verboten in any case that you're involved in.
Right. Read it. Read the signs. I own mortgage specialists. Anybody suing me outside on this? No. He's been known to sue people. But why wouldn't you? Be slanderous if I'm lying. Yet I challenge them to. They won't. They know I'm telling the truth.
His statement's over, and again, I'm going to have to disregard. All you need to know from Mr. Hill's standpoint is that he is taking a legitimate position that he was overcharged excessively as a result of what he claims are acts by the Wiggin law firm. That's what you're being asked for. Don't miss this. Judge McHugh just told the jury to dismiss my whole opening statement, and Mr. McHugh made my statement for me.
This divorce was over in minutes. She just tried to kill my son 3 times. It would have been over. They know it. You can't collect millions of dollars and having a divorce end immediately. There it was. And when they turned around and had the records, they couldn't come back with them. And that's why we had to go through statute. Listen, there's no dispute that I spent $5 million. They're not disputing that it went on for over 5 years. My little girl's going to be 20 next month. Thank you.
Again, you have to disregard that because it has nothing to do with the...
Disregard we have children at all. Just a bit.
Call your first witness.
Thank you, Attorney Ross. Raise your right hand, sir. Do you swear the testimony you're about to give in this trial will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You can be seated with the course of convention. My papers. Attorney Ross, could you please introduce yourself to the jury in terms of your name and where you live and what you do for work, please?
My name is Jonathan Ross. I live in Portsmouth, New Hampshire. I'm a practicing attorney whose practice concentrates on enforcement relations.
How long have you been practicing and how long concentrating in domestic relations?
I began practicing in New Hampshire in 1968. I've always done some divorce work since 1988. I concentrate on practice on domestic relations work.
Any particular kind of domestic relations?
My practice from that point on really has 2 parts: pro bono work for people with limited means, and what I would call high-end divorce that includes significant assets and substantial income.
Just briefly, Attorney Ross, number one, how old are you?
I'm 71,
And you're still working full-time?
full-time.
And just ever so briefly, your educational background.
I went to Hobart College in Geneva, New York. And then went to Georgetown Law School. And after Georgetown, I spent a year getting a master's in law at Harvard Law School.
And when was that?
Graduated from Harvard in 1968, and then came to New Hampshire to practice.
At some point, you came to represent Mr. Gill for a portion of his divorce proceeding.
Yes.
And you described to the jury how that came about.
I received a call from someone at Divine Element saying that they had a client by the name of Michael Gill. David Phillips in that firm was representing him. There was a conflict of interest raised concerning their firm. And would I be willing to take Mr. Gill on? He said yes, and the file over, and ultimately I met Mr. Gill.
I'm going to show you or hand you a notebook that has 3 tabs in it. Attorney Ross, could you please have an extra one for the court?
No.
Could you please just briefly identify what the 3 documents are in the notebook, Attorney?
I understand it's slow right now, but John Ross is perjuring himself. The past New England president of the Bar Association is flat out perjuring himself. I want you to take that testimony and read Dallas Sedgwick's affidavit that I have attached, and you can see that everything he's saying is perjury.
Ross?
Exhibit 1 is the fee and engagement letter between Michael Gill and my firm, Wiggin Nourie, PA, dated August 2, 2007.
Okay, that's number 1.
Yes.
And what is number 2?
It is copies of the Wiggin Nourie invoices to Michael Gill during the period that we represented.
And number 3, sir?
This is the Rochester Family Court index or docket listing for all of the activity in the case. The case originally started in Rockingham County and was transferred by special assignment to another judicial officer who ended up sitting in Rochester, which is how it got there.
Your Honor, I move to strike the ID on plaintiffs 1, 2, and
Mr. Gill, you having problems with these exhibits, having the jury see these all?
What are the exhibits? The bills?
The engagement letter, the bills themselves, and also the docket sheet listing all the activities you did.
No problem.
Okay, fully good.
Your Honor, if it pleases the court, I have one of these notebooks for each of the jurors that will be making extensive references to this. Can I publish them?
Yeah, please.
Attorney Ross, I asked you to look at exhibit number 1, along with this, and again, what is that?
That is our fee and engagement letter that was drafted and sent to Mr. Gill that he later signed and returned.
And what is an engagement letter?
It's a written document that sets out what the law firm is being hired to do and what the payment and other arrangements are between the client and the law firm.
And did you in fact prepare this letter we're looking at, exhibit 1?
I did.
And what are the considerations, if you will, that go into what is included in a letter such as that?
It's important to set out what somebody's relationship with the law firm is when you're hired to do work for them. So this document includes what the firm is being hired to do. It sets out that if there's anything additional, it must be in writing and confirmed, because we want the client to understand that you're being hired for a particular purpose, and you're not a lawyer generally for anything that might come up in their lifetime while you're representing them. You then have to set out time to work on the case, so they have some sense of how the law firm will handle their work. You set out what you're going to charge and the basis for it. You set out what the expectations are of the client and from the law firm, what the out-of-pocket cost might be and how that's determined. You make sure that the client understands that the client can terminate you at any time if there's no right to be somebody's lawyer. And likewise, there's no involuntary.
Mr. Ross is giving you the definition of the engagement letter. Except for, doesn't it sound more like a release? And that's exactly what it was. Because they knew they were going to commit fraud. They knew they were going to steal millions. And they needed that release. And you know what? Because they knew one day they were going to wind up in court. And there he is. He was right.
The lawyer's part, the lawyer has a right to withdraw if we find that a client is not truthful with us or for any other reason that we determine that we can't be of service again. So the purpose of it is to meet our ethical obligations and to try to make full disclosure to what the relationship will be.
And those features are included in this July 18 letter, July 18, 2007 letter, Mr. Gill?
They are. This letter was written for Mr. Gill in parts, but this document is a format of fee and engagement letter that I drafted some years before this, after attending some continuing legal education courses on what should be in one of these things.
And before we look at some aspects of the letter, can you just verify for me that on page 3, that you read, approved, and accepted by Michael J. Gill? Is that right?
Yes, dated August 2, 2007.
Let me go back. I don't want to belabor Attorney Ross, but there are some aspects of the letter I'd just like to highlight for the jury's use in considering this case. gather the first paragraph explains what you've already told us as to how you came to represent Mr. Gill in the first place.
Correct.
The second paragraph, at the beginning, again, does this reflect what you described to us that the letter sets forth the basis upon which you represent him?
The third paragraph sets out specifically what we're being asked to do.
Oh, I'm sorry, I was in the second paragraph, the first sentence.
Well, it points out that this is a legal document between us. It's a fee agreement that's capitalized to bring attention to it. And I make the point of putting in that letter, the client, this prospective client, has the right to consult another lawyer about the terms of this if they choose. So that the beginning of that relationship is fully arm's length.
And am I correct that in the third paragraph, in the middle, you outline what it is you engaged to work on?
Yes, sir.
If I can ask you to turn to page 2 of the letter, just to turn it on, and I'm focused on the second paragraph that begins, "You will hire the firm." And what does that mean?
It means that there is not a personal connection between the client and a particular lawyer, that we work for Wiggin Nourie, and the client is hiring the firm. Part of the reason for that is that you want the client to understand that the person they're talking to is not necessarily going to do everything on their case.
And in this particular case, though, Attorney Ross, was there some understanding as to who was going to be responsible for the harassment of the case?
Yes, this was a large enough case that I asked my partner, shareholder Darla Sedgwick, to be co-counsel on this case, and I disclosed that in this letter so that it would be clear to Mr. Gill that she would be involved.
And I don't, as they want to be labored, but dropping down 2 paragraphs, the letter indicates we were going to be monthly,
Correct?
and that's what you did.
That's what we did.
You expected payment within 30 days.
Yes?
The following paragraph talks about the hourly rates for yourself and the other lawyers who might be working on the file.
Yes?
And then finally, I think, Attorney Ross, the very last paragraph on that first page addresses the issue of cost. And what do you mean by cost here?
Well, they can range anywhere from travel format overhead, copies of telephone, that kind of thing, for special delivery documents if need be. We have to pay copies of bank records, for example. Those are expenses that are passed through to the client.
And what about this last paragraph in reference to fees for experts? What does that mean?
Well, in a case like Mr. Gill's, where you had business interests, some tax issues, everything that was at risk, the need for an
Attorney Ross, you were my attorney, is that right?
yes,
Yes. You heard me speak to the jury briefly about my children. How many children do I have again?
you told us you had 5
And how many boys?
or
Okay, all right. Did we spend much time talking?
you and I together.
Yes,
Total
me
scheme.
and you.
Total scheme of things, no.
20 minutes maybe total? In Ed?
Much more. It's reflected in the invoices.
Or the bills? Okay. Would you agree that, well, let's start by saying, would you agree that Ms. Sedgwick did the bulk of the work for the divorce?
Yes.
Yes. Okay? Is Ms. Sedgwick still working for you?
Wiggin Nourie no longer employs anyone.
Did she quit before Wiggins and Nourie closed down?
She resigned for shareholdership, yes, to take another job.
She quit. She took another job.
Say that, said she quit. She terminated her.
At some point toward the very end of my relationship with Wiggin and Nourie, I told Ross that I know what is going on here. I recall making a statement along the lines of, "How much money do you need?"
Relationship with my firm for another job.
Another job. Who was your last case?
Well, yours was one of her last cases.
Well, that would be me. Did she tell you why she was leaving? Was it for another job? Because she didn't have another job.
You can't get information from
Well, it has to do with the bill.
I know, but the person that offered that information.
Well, I'm
is
asking-
Sedgwick.
How long did Ms. Sedgwick work for you?
I don't know the answer to that. I can't remember when she joined us.
Years? Years, right?
Number of years, yes.
Number of years. And she quit. Last case was my case. Did she come to you and say that she wasn't going to cooperate with getting past the statute of limitations? Did she tell you that?
That information has to come from.
I'm asking his knowledge.
No. To test the validity of that, you need the person making the
Well, the
statement.
person worked there for years. I'm the last client. Did she talk to you about my case to do with fraud or anything? I'm asking, not here, I'm asking Mr. Ross.
I
Did
know.
you have any discussions with Ms. Sedgwick regarding fraud or criminality?
That's okay. Did you have any discussions?
No.
You did. Okay. Let's go over the bill. Let's do this here. Do you know Mr. Tober?
Yes?
You do. Was Mr. Tober the attorney that replaced Ronald Wise and Matt Kosel?
He had an appearance for your wife after Ron was.
So yes, right? He represented my wife.
Let him finish the answer.
Well, let's ask you again. Do you know Mr. Tober?
Yes.
Are you friends?
Yes.
I mean, there's some issue here about some collusion, so that's part of the.
Mr. Tober's on the bill. I'm saying fraud. I spent a lot of money on this bill to disqualify Mr. Tober with the relationship with Mr. Ross that was never filed. And that's the last time I saw Mr. Ross. It's all pertinent to the bill.
Okay, we're gonna go through this by bit, but you're right, Mr. Hill, there's a discussion in the bill about filing a motion to disqualify Mr. Tober, for which you were charged. Okay, so let's put
Absolutely.
it,
A lot of money was charged. Now,
zero in on that if you want.
I'm trying. So, you are friends with Mr. Tober, and Mr. Tober did come in after Ms. Wise and Kosel suddenly left. You just made $1 million, but no, we gotta get out of the case. So,
You can't editorialize these things.
well, I
Just ask
apologize.
fact questions.
Okay, so, you are friends with Mr. Tober. You vacation together?
Yeah.
You go out to dinner together?
We have.
Would you consider him maybe your best friend,
No.
but a good friend?
Yes.
He was representing my wife, was he not?
He was.
Did I not go to Miss Sedgwick and say, I'd like to see Mr. Tober disqualified?
I also knew that Tober was very close to Ross, that the two were good friends, and that Tober had previously represented Ross.
Because, spoke to you about this, something fishy went on. And I believe that Wise had the therapist records. Did I bring that to your attention, that I believe that they stole the therapist records and Attorney Wise actually had them? Didn't we have that discussion?
Wait, Mr. Gill, you can't have compound questions. You started with, was there discussion about his disqualification? Stop there.
Okay. Was
There
there,
was discussion about whether Mr. Tober could be disqualified if she was.
discussions cost me? Maybe 100,000 maybe? Is that possible?
I don't think so.
Well, I think we should look at the bills again. Because I think you'll find, outside of the mental issues of the therapist records, it was a disqualifying Cobra. Did you ever tell me that you were friends with Mr. Cobra?
I don't recall that I did.
Neither do I. Did Mrs. Sedgwick use Mr. Tober as an attorney before? To your knowledge?
Again, that may play in, and the specifics I don't want to know, but if it deals with some of the discussions that went into whether or not to file the motion to disqualify for which he was charged, tangentially, it may have some bearing. And the last question is okay.
To my knowledge, prior to our representative, Mr. Tobin represented Sedgwick in personal treatment.
How much longer before she represented me? Could it have been months?
I don't know the dates.
Okay. So let's go back. You're friends with Mr. Tober. Does Mr. Tober represent you as an attorney?
Does he?
Has he? Oh, he has. So Mr. Tober is your attorney, is that correct?
No, it's not correct. Mr. Tobin represented me prior to my representing you, totally unrelated.
Could you speak a little louder? An unrelated matter. So we're friends, and Mr. Tober represented you as your attorney.
In Ross's opinion, no conflicts of interest existed by virtue of Tober's involvement. Ross never discussed with me the subject of Tober's prior representation of him. Again, I could not understand why Ross seemed to be fighting not to move to disqualify Tober.
Once?
My memory is once.
How about the business that you were the president of? Did he represent that?
He did some work for Wiggin Nourie in his prior matters.
Were they both malpractice cases?
Objection, Your Honor.
I'm asking him to
Yeah,
take
but the issue now is whether or not he was billing you properly for this issue of disclosure.
Absolutely.
But the particulars of that is
Well,
not
I'm trying to state that not only they were friends, he was his lawyer, and he represented, well, as there was two malpractice suit against you.
That's not true.
The particulars are important, sir. You've established that there was a relationship there.
Well, I also want to say not just a relationship, he was your attorney. Now, what was the time between Mr. Tober represented you in a malpractice suit and then he represented my wife? How much time in between?
I'll leave on the malpractice suit piece, but the former representation, okay, and the current, and the representation of your wife.
Right, because we are talking about a motion to disqualify Mr. Tober, which I asked him to do, and we spent a lot of money to do it, never disclosing you were friends. Now, what was the time between Mr. Tober representing my wife and the last time he represented you individually for malpractice? How much time?
Somewhere between 6 months and a year.
Oh, I think it was days, but we can check. Days. They waited for him.
Objection, Your Honor.
You can't comment on it, sir. You got the answer. If you don't like the
Okay.
answer and you have some personal knowledge, you can testify about it.
All right, so, he was your attorney, you were friends. So I'm asking Ms. Sedgwick, you had discussions because you said out here that you reviewed the bill and you discussed. Your job is to discuss what was going on and what they're doing. Is that so?
I don't understand your question.
I'm saying what Mrs. Sedgwick is doing, you're conferring with her and talking to her about it. I hired you as my attorney, is that correct? That was the explanation you gave here.
Yes, you hired my firm and me as your lawyer. Yes, during the course of your representation, I talked to Ms. Sedgwick.
Okay. Did she tell you she was filing a motion trying to get Mr. Tober off with the fact of relationship between her and Mr. Tober? It's on the bill. I paid for it. Why?
I'm clear on the question. She's talking about
I think the question is, was there a conflict between Mr. Ross and Mr. Sedgwick about disqualifying Attorney Tober?
Right?
The answer to that question is yes, you
Was there further talks, seeing that we had talks with Ms. Sedgwick about disqualifying her, why not you? We're your friends and he was your attorney. Was there discussions about putting a motion together with your relationship and getting Mr. Tober off? Did you create a motion with the response with Mrs. Sedgwick and yourself? Did I pay for a motion for you to write?
Your Honor, if Attorney Ross was given the opportunity to answer all those questions in local fashion,
It's easier for him if you ask one question and stop and then wait for the answer.
I don't mind if he just gives me a chance to answer.
And I think that's the last question.
I can answer it globally, I don't have the information.
Well, let me simplify the question. We established that you're friends and that he was your attorney. Why, if it was okay, you just said you knew that Ms. Sedgwick was writing a motion to exclude him because of her relationship, why wouldn't we put you on a motion where he's your attorney just prior to that and your friends? Why didn't you put that motion in?
May the witness now answer, Your Honor?
Yes. Good.
It was brought to my attention, Mr. Gill, that you wish to disqualify Mr. Tober because of prior relationships and friendship
Could you speak
Mr.
louder,
Tober
please?
and me. I looked at the rules of professional conduct that govern lawyers. Part of my job at Wiggin Nourie was to be the person deciding ethics issues for all of the lawyers in my firm. And I made the judgment that the things that you were asking about were not a legitimate basis for you and your law firm to seek to disqualify your wife's lawyer.
Okay, thank you.
I'm not done.
All right.
I was very sure about that. And it was brought to my attention that you were unhappy with that decision and wanted to push the issue. And so, because you were insisting that we do this, I asked Ms. Sedgwick and Ms. Beauregard to do legal research, independent of what my thought was, to find out if I was right. And they drafted the best motion that they could think of to do what Mr. Gill was asking us to do. And I read it, and I looked at the cases that were cited in it, and it confirmed my judgment that it was a frivolous motion, that it had no basis in law, and I declined to file it. And I told Mr. Gill, I told you that I would not file it, but that, excuse me, that I would not file it, but that you were at liberty to take it to the Divine Law Firm who represented you and to the lawyers in Boston that you said you had, and let them file it for you. And it was not filed. And I charged you for the time that I spent doing that at your request.
You spent $100,000, and then you thought it was a bad idea. Here's an idea. Think it before you spend $100,000. Bottom line here is, you never told me. Did you ever tell me you were friends with Tober?
Prior to the discussion about a motion to disqualify him, no. And I didn't.
How about the
because-
fact that he was your attorney?
You gotta finish.
I didn't discuss it with you because in my judgment, it has nothing to do with my ability to represent you independently. I have tried many cases with Mr. Tober. I have tried cases with other lawyers in this small state, most of whom I know. And if the fact that I was friendly with any of them would not let me practice law, I wouldn't have any work to do. You have to be able, as a lawyer, to
He
represent
answered
your
the
client.
question he's preaching.
No, no.
All right.
You have to be able to represent your client and put those things to one side. And I've done that for over 45 years. This was no different. It's not an issue for me.
Which is why we had a malpractice case before that, and this. And why, well, Dollar Sedgwick quit. Is that correct? She's left. We established that, correct? Have you spoken to Ms. Sedgwick yet? Since? She's on the bill. We can't find her as a witness. Is it okay if they talk?
Again, I'm just looking for a yes or no answer. It's nothing to do with specifics.
Spoken very.
Have you spoken to Ms. Sedgwick since this?
This meeting.
Since Since the lawsuit was filed?
I asked you if you spoke to her.
What period of time, sir?
Well, I don't know. If it's multiple times, let us know.
Since when, sir? Are you asking?
Since this end, I said. Since she quit and left the employment of Wiggin Nourie because of this, have you had discussions with her since?
No.
This would be since June of '08 till now.
I will strike the question, Your Honor, but no objection.
Yes, the question, basic question, have you had any discussions with her after June of '08? The answer was no.
The
You
answer-
have no contact with her.
I have not had any discussions with her. I saw her in November of 2011, I think, at your lawyer's office and said hello. That's the only contact I've
Okay? Let's go through this. So would agree that the beginning of this divorce was the therapist records. Is that correct?
had. That was one of the issues.
Dr. Broussard, is that correct? Was a therapist.
Dr. Broussard was reportedly your wife's therapist at some point in time.
Do you remember what he said? So you represented me in getting those therapist records. Is that correct?
Yes. We made efforts to do that, yes.
And did we win? And did we get an order to get those records?
We got an order for them. We got an order for his deposition. And before any of that was done, he fired us.
What happened to the records?
I have no idea.
Well, wait a minute, you were my attorney at the time. They indicated 3 means of destruction. You don't recall them?
You asked me if I knew what happened to the records. The answer is no.
Okay. Were you informed? Did you see any letter or read anything in writing that the records were destroyed?
I recall hearing that, yes.
Did you read it or hear it?
I don't recall.
Did you hear that they were destroyed 3 different ways? Does shredding remind you of anything? Does flood?
I recall that somebody said at some point in time that the records were destroyed in the flood, yes.
So you remember the flood? A flood destroyed the records. Do you remember the flood?
I don't remember the flood. I
All
remember
right.
the
So
statement.
3 means of destroying them. Now, what happened after that?
What happened after what?
Well, we didn't get, what happened to the records? They were destroyed. Now, the hearing went on all summer. That's what cost all the money, was trying to get them. Only to win, which is correct, we won the hearing. We had an order to get the records. Do you remember how long it was between we had an order and the records were suddenly destroyed? Even though the therapist had notice all summer long. He said they get destroyed in July, and we were in September, October. Do you remember how many days after we had the order that the therapist records were destroyed?
I don't know that they were ever destroyed, as a matter of fact.
This is a very important moment. He just got 3 means of destruction. Of one, the flood. Does Mr. Ross believe that the therapist's records swam to safety? So you think about this. Mr. Ross cannot tell us that he knows Wise has the records, but he has absolute knowledge that they weren't destroyed. That's why he's evading that question. Wise and Ross both knew if those therapist records became public, the divorce was over and they were not going to make millions. So instead, they put my 5 children at risk. You know what? I don't think they were destroyed either. So that's my next question. Do you know what happened to them?
I don't.
You don't know that Ronnie Wise had a copy of them.
I don't know that.
Did you have a discussion with Bella Sedgwick about Ronnie Wise having those?
Can't answer that in the context that you asked it. We talked
Did you
about.
have a discussion?
Yeah, finish.
Did you have a discussion?
Finish the answer.
Sorry, I'm done.
What was that again?
Ask another question.
So you believe potentially the records weren't destroyed?
I didn't say that. I said I didn't know whether they were or not.
You did. Well, we know that they were said they were destroyed 3 different ways. Not directly, but you could read it, because it was a motion that was sent to the court. I spent hundreds of thousands to get us there. I would hope you would at least read it. Now, upon reading it, do you realize it was only 3 days after the therapist got the motion that they were destroyed? What happened after that?
I can't accept your predicate, sir. I don't know that they were destroyed.
Well, we never got the therapist records, did we? Don't miss this. He doesn't answer the question, but he does say that his paralegal had Dr. Garber's records and matched them up with the therapist records. Guess what? We didn't have the therapist records, remember? There was nothing to match it up to. That's a straight out lie.
Not that I'm aware of. Certainly not while
Not
I'm...
during your position, right? Never got the therapist records. So, we never found the motion that said you were a friend, and you never spoke to me about it. Do you think it would have been a good idea for you to talk to me about the relationship you had with Tober? No?
No.
So the fact that Miss Sedgwick obviously didn't she?
I don't know what she talked to you about.
Well, didn't she write up a motion of, I don't know, 40, 50,000? So, weren't you part of that?
The motion that was drafted was done at my request, as I testified. Double-checked my own judgment about whether there was any basis to file it.
Why never I saw that motion? Levine had that motion. So in case you're saying it wasn't written, I'd be careful about, there's a copy out there that says you did write it.
I didn't say you did.
Cue to the rescue. God forbid Ross perjures himself and says that he didn't have that conversation with Sedgwick. McHugh knew this and came in and shut that questioning down. Oh, you didn't say...
He said he wrote it.
No,
He
no,
ordered it. He examined it.
And then he made a conclusion, not before you charged me $100,000, only afterwards. And while he was going through this process of examining it, he never once told me. As the client, I would have liked to have done that. All right, let's keep going. You managed it.
Yeah, that wasn't a question, that was a comment. So go ahead, next question.
All right, let's go over the bill. You know what? January, oh wait. I didn't see anything down here. Annette, was that just a misprint?
What page are you on, sir?
January 9, 08. Your bill. Thank you.
Page 36. All right, I'm at page 36 for the January 9 bill. What's your question, sir?
I don't see any total here. Hey, let's take a look at the bill.
Are you asking me what the total amount due was?
There was discussions with the guardian that line. Did you speak to the guardian?
What date and what entry are you referring to?
September 07?
What date and what entry, please?
Well, I'm asking you a question.
And I'm
It
asking
says
you to
here,
show me-
Attorney Ross regarding appointment with Tim Cunningham to GLA. I'm asking you, you're a long-term time divorce attorney. I'm assuming you speak to the guardian about my children-in-law. Did you?
Would you refer me to the entry that you're making reference to, sir?
Well, it says here, on your bill,
What date? September what date?
there you go, on 8/22. Notice to review for court appearance, review of guardian appointment was received. Attorney Ross regarding appointment with Tim Cunningham at GLA. Will you charge me that you talked and met with Tim Cunningham? What was that about? Tim Cunningham is the GLA on the case, which is the guardian ad litem who interviews my children, goes through the therapist reports. Did you have a meeting with him?
Mr. Gill, the entry for August 22 is a charge by Darla Sedgwick for her talking with me about the appointment of Tim Cunningham because he had been a guardian ad litem in cases that I had handled prior.
Did you speak to the guardian ad litem concerning his reports about my children? Yes or no, please?
I don't recall without going through
You don't recall.
I don't recall.
You're my attorney.
Yes?
I spent about over 400,000 with them. You don't recall that you talked to Guardian ad litem?
I don't.
Oh. Did you speak to Dollar about what the Guardian ad litem said?
When he said what?
Did you speak to Donald Sedgwick, your underling, about what was concerned with the Guardians and what they read?
About what? When?
I'm asking you.
I don't understand your question as a point in time. I've told you I don't have an independent memory presently of speaking with the Guardian.
So you have no memory of speaking to the Guardian ad litem. Yet, in the beginning of divorce, if say for instance, I had a child who had 3 attempts on his life, and that was in that Guardian report, wouldn't you consider that important? Especially when we're in there from the beginning dealing with therapist records. It was also what the children were saying. Why wouldn't you know that? That could have brought the divorce to an abrupt end.
The problem, sir, is we're mixing now theories versus, we're trying to focus in on what you were charged for. So you asked a legitimate question. You said on August 22nd, where he was charging you with something to do with the guy.
Then I would ask you this. Is it quite common for a divorce attorney, when there's children involved, to speak to the Guardian ad litem?
Yes?
But you don't know if you did.
I don't know if I did. I know that Ms. Sedgwick had that
But yet,
responsibility.
you are, the beginning of this divorce,
Go ahead. You know that Ms. Edwards, go ahead.
I know that Ms. Sedgwick had contact with Mr. Cunningham and had a lot to do with the work that was done in connection with the parenting issues. It's reflected that she did that.
parenting issues, wait a minute. So the therapist records, we now know, were all destroyed.
We don't know that.
Well, we don't know where they are, you don't have them, and I spent a lot of money to get them, is that true?
I don't know where they are. And
But did I spend a lot of money to get them, and do I not have them? He's answering a question to the question I'm not asking him.
What's a lot of money, sir?
Oh, I don't know. Between what I had to pay for my wife and myself, I don't know, $1 million, a lot of money? Let's see what happened. We didn't get the therapist records, did we? We didn't get Tober removed, did we? So what did we accomplish?
May the witness now give an uninterrupted answer?
Sure. You want to go ahead, Mr.
So,
Okay.
Ed,
we did not get the therapist records. The last order that was entered was to depose Dr. Broussard and have him produce records to the court. You terminated our representation before that could be done. My understanding is that you never got them from any subsequent counsel.
okay, well,
And the
Then I
motion
asked
to
this.
disqualify was not filed. Let me just finish answering your other questions. The motion to disqualify Mr. Tober was not filed because I made my professional judgment that I would not do so and offered you the opportunity to have another lawyer do it for you.
and we keep going back to the same. So, there was no mention of getting Dr. Broussard deposed. In fact, he said he had his records destroyed. What were you going to get from the records? How about this? You said you don't remember the Guardian ad litem reports. But if we lost, we couldn't have the records. But if they lost, we didn't get them. It could have been one of the multiples. Wouldn't you have then asked the Guardian ad litem? Because I'm making suggestions that my son is threatened. And fact is, later in the divorce, we find out from a court-ordered therapist that came in here that they insisted on. Guess what? Clay was just depressed. But the order was, he should never see his mother again.
Okay.
Now, do you think it would have been important to know about the Guardian report? Why wouldn't you ask and know about the Guardian report if you knew my concerns with the mental illness of my wife from the beginning of the divorce?
I still don't know what question you're asking me. Could you ask me one at a time?
The Guardian ad litem report.
Yes.
Once the therapist records were missing, they claimed destroyed. You claimed it, maybe not. But we didn't have them. Wouldn't it have been quite natural to speak to the Guardian about the welfare of my children and what they were saying?
can't answer the question as phrased.
Me to have question, comments.
The best way
I'm
to-
asking a question was there a concern? Would you not say that the welfare of the children is paramount in a divorce case, Mr. Ross?
Welfare of children is a paramount issue for parents and in a divorce case, yes.
Thank you. So why wouldn't you speak to the guardian, particularly when the concern from the beginning of them coming in was the health and welfare of my children?
I didn't say I didn't speak to him. I said I don't remember speaking to him.
Well, he didn't speak to him. And
Sorry.
Let's just have evidence from the guardian.
how did you become my attorney, Mr. Ross?
You hired me, sir.
Right, off a referral from, you didn't remember his name. Do you remember Alice Walker now? You're gonna see him, who's the president of Divine Nomad. You know Mr. Walker.
I do.
Is he your friend?
No.
Okay. Did he refer me to you?
My understanding is that I was referred
So you do remember?
to
It was
by-
Mr. Walker.
Let him finish. Go ahead, by whom?
by either Mr. Walker or Mr. Phillips. I was not privy to their conversation.
Yeah, when I met you, Mr. Walker. Okay. Did Mr. Walker, did you pay Mr. Walker? Was there any referral fees between you and Mr. Walker?
No.
Did Mrs. Sedgwick meet with Mr. Walker?
I'm sure she did.
She did.
Sometime during our representation of you, she did. I know that because she was with me when we met with him on several occasions.
Mr. Ross has a questionable memory. In the beginning of the deposition, he forgot even that Walker referred him. And now, he's having a meeting with them because he feels obligated because he did. You can't get it both ways. The reason why he had that meeting, they had to go to Plan B. Walker couldn't have them lose control. See the organizational chart that I presented you. Walker was the puppet master. That's what he was doing with Ross. What about the last meeting?
I don't
Were you
know-
there?
I don't know what.
When they discussed malpractice?
I don't know.
You weren't there.
What I'm not clear about is whether or not there was some special billing for potential malpractice claims. There's no billing for that, I don't know.
Yes, they billed her time to speak to Mr. Walker about the malpractice. Mr. Walker told her to get out of town, and she did.
That's not true.
You can, sir,
Well,
Mr.
it is
Gill,
true.
Mr. Gill, you're making a representation that you know somewhere in that bill there's the word malpractice and a discussion about that and a bill to you. Is that what you're saying? You know?
Yes.
Okay. I'm going to give you 10 minutes to try to find that. I got to give you folks a break. We take an afternoon break, okay? You find it.
All rise, please. The honorable court is in session.
Have a seat again.
I'm asking you, Mr. Ross, you are aware that Ms. Sedgwick had meetings with Mr. Walker, Attorney Alice Walker.
Cedric and I both had meetings with Mr. Walker and others.
Say it again.
Ms.
Are you
Sedgwick,
aware that they were meeting?
at what time frame and in what context, sir?
Did they meet ever? Did my personal attorney meet my divorce attorney?
Ms. Sedgwick and I met with Mr. Walker and others at Choate Hall and Stewart in Boston about your tax issues. We also met with them in the Divine Millimet office on the same issues.
Do you know the meeting that they had just prior to her leaving?
I do not.
Did you have discussions with Mr. Walker at any time about those meetings?
No, I didn't know any such meetings took place.
So if Mr. Walker said he had discussions with you, he would be not telling the truth.
He would have a different memory than I have.
Oh, so he could be telling the truth, if his memory is better than yours.
Possible.
Wow. All right, you still got the May bill.
For work in April or a bill for work in May?
May 20th, we'll go to that line. It says June 5 on the bill, but it'll represent the work that's done in May. Averages to
I'm on May 20, 2008,
it.
page
Okay,
121.
all right. So, this is towards the end of our relationship. Many months, when we said the therapist records went missing, and I asked you the question of Mr. the GLA, and you had no memory. On your bill, now this isn't when it should have been done in April and May, but a year later, almost, a telephone call from Dr. Garber about the missing CLM records. LJR, is that you, Mr. Ross?
That's me.
Okay, so you had discussion with the GLA, the guardian ad litem, Mr. Garber, about missing records. I just couldn't see it here on my bill.
Dr. Garber wasn't the guardian ad litem, to my memory. It was Timothy Cunningham, wasn't it?
Oh, we had two. Mr. Garber sat down with the children, says here you talked to him about missing records.
There was a suggestion, sir, that Dr. Garber, who's a psychologist in Nashville.
Yes, I know who he is. I'm asking you a direct question.
Let him finish. Go ahead.
He's avoiding the answer. I've got on the bill that you billed me, that you had a meeting with Mr. Garber, and it was regarding the missing records that you don't recall.
Making answer to the pending question now, please.
Excuse me?
You wanted to explain the entry that's five.
I want to go over the bill. They've narrowed it down just to a number. So let's deal with the number. Mr. Ross said he has no memory of the GLA. Yet, most important thing is the children in the beginning. Well, he has no memory, yet it's on his bill, and he refers to them as missing records.
Your Honor, this is argumentative.
What argument? It's on the bill.
You're making it so that he can't understand what you're asking him. Let me pose the question for you, okay, on this one issue.
Well, I thought it was pretty direct. Go ahead.
Okay.
You get it.
There is a line, Mr. Ross, right, 520 that you referenced. It says telephone call from Dr. Garber with missing record.
Yes.
Okay, that's with you. Do you remember anything about that call, what it was referencing to?
There, to my memory, Your Honor, there was a suggestion, and I don't remember where it came from, that Dr. Garber had seen the records from Dr. Broussard. And so I had a telephone conversation with him to find out if that was so, and if he had the records. That's what that entry reflects.
About the missing records. You don't call to find out they're missing unless you know they're missing. So you had a conversation which you didn't remember having just a short time ago.
No, sir, Dr. Garber was not a guardian ad litem.
He's a therapist that's court-ordered, that meets with your children to analyze them, health-wise, tests. Do you remember Mr. Garber gives those tests, is that correct?
Yes?
He does, okay. Do you remember what the test said about my 3 children, or my 5 children, but my 3 youngest children? Do you remember their responses?
That is not relevant, as I said.
It's part of the bill.
You're billed for his time, okay?
Right.
He's explained why.
Well, his bill for the time had to do with the health of welfare of my children. I explained to Mr. Ross, did I explain to you not that she was a borderline personality disorder and tried to kill my son 3 times? Did I tell you that, Mr. Ross? Ms. Sedgwick?
Objection.
Again, that's totally irrelevant. We're talking about
It is-
entries, we're talking about entries in the bill, right?
Well, here it is, the bill. He had no reference to speaking to the therapist, court-ordered, regarding the welfare of my children. Now, when it comes down to his own bill, about the missing records, I'm asking you, you worked with Mr. Garber. The issue of the welfare of my children was paramount, particularly in this case. till you realized it was missing. Is that correct?
I knew we didn't have them.
Well, your bill says missing.
Correct.
So, so when we have no memory of what Mr. Goddard told you about the evaluation of the children,
That was not discussed in the entry for May 20. I called him to get information.
well, you
about
didn't
what-
remember what you said before, now you tell me it's not discussed. I'm asking you directly, do you remember either looking at my children's therapist records that Mr. Garber produced, or did you have a talk with Mr. Garber about those records? First part, did you see Dr. Garber's records on my children?
Presently, I don't recall.
His life was in jeopardy. You don't want to look? You don't want to recall? This isn't important?
Objection, Your Honor, argument.
Okay. Now, on the 20th of May, too, you sent an email to Alice Walker in a reply. Do you remember what that was?
I don't.
Why were you discussing Alice Walker about my divorce case?
The entry is that I got an email from him, and I replied to it.
Witness identification on June 16th hearing. What is that about? Spoke to you.
It's about what it says, about identifying witnesses for a hearing that was scheduled for June 16th.
Who were those witnesses?
Presently, I don't recall, no. We were out of the case by the June 16th deadline. And that hearing was postponed because you asked us to leave.
Later on, May 20th still. God, we're comparing records in file. Nothing that these are not missing records that I'm looking for.
Where are you?
Correspondence with, well, this is on the same day, Mr. Ross.
Yes?
Correspondence with Mr. Ross, direct contact with Dr. Garber, incomplete records. Uh-oh. That's your next line.
Are you
So
referring to the
do you remember
entry?
that?
Excuse me, are you referring to the entry by paralegal Lynn Casker as the last entry on page 121? For
Yes, I will. It says correspondent with Attorney Ross regarding direct contact with Dr. Garber and identified incomplete records.
That's where,
Don't miss this. He doesn't answer the question, but he does say that his paralegal had Dr. Garber's records and matched them up with the therapist records. Guess what? We didn't have the therapist records, remember? There was nothing to match it up to. That's a straight out lie.
the paralegal did in comparing records to see if there was anything missing in what had been produced.
What does correspondent with Attorney Ross mean? To Dr. Garber. Says here the subject was incomplete records. Mind you, this is about 8 months after I hired you.
It reflects what the paralegal was looking for.
She refers to correspondence with you, Mr. Ross. And you having direct contact with Mr. Garber.
Objection, Your Honor. It's a misstatement of the entries, and Attorney Ross should be able to answer the question.
This is all part of the bill. This is what I paid for. I'm showing you what I paid for.
But if that entry is troublesome to you, sir, let him explain what it means, then you can question about it, if you disagree with him.
He hasn't explained anything.
Give him a chance.
Go on.
The entry for May 20 by LLC, who was a paralegal in our office at that time, reflects that her assignment was to review certain records, one of which was to look at the facts of records from Dr. Garber and compare them with what we already had in the file, and noting that the records that he had sent in response to my contact were not incomplete. That's what I understand this to mean. She was asked, excuse me, she was asked to take one set and compare it to another set to make sure that what we had produced with the saying that there were not incomplete records. That was her assignment, that's what she billed for, her response is
But
there.
that's not the question, is the answer to the question, is it? Because the question was, again, I'll ask you, direct contact with Mr. Garber about missing records. Not, we put it here, we put it here, we put all these boxes that they'll never use to show you what 20 they spent.
That
Smoke and mirrors. I'm asking you a direct question.
That reference, sir, in recorded in my time, I've explained it was a telephone conversation to find out for myself whether Dr. Garber had Dr. Broussard's records, and he did not.
Well, what'd you do when you found out that they were incomplete? After 7 months?
I didn't say they were incomplete.
Missing?
Dr. Broussard's records were
It
not
says
there.
incomplete on your bill. I paid for the word that said incomplete, sir, with your name on it.
You're missing up the Broussard records from the Garber records.
I'm going back to Mr. Ross speaking to Mr. Garber, and he identified them as incomplete.
No, it said missing.
Mr. Garber, therapist Garber, Dr. Garber, had a conversation with you, and you with him, and said that the records of my children, particularly, well, my wife's therapist records, were missing. Is that right? Says incomplete missing. That he had a conversation with you.
I called him to see if he had the records of Broussard that we were unable to find. He did not have them. The other entry is comparing two sets of records to see if the second one that was produced was different than the first, and they were not incomplete.
You find that unusual that the therapist records go missing? Is that customary?
I don't have an opinion on that. I don't know what's
How
customary.
many years have you been a divorce attorney? Has therapist records come into play?
Sure.
What was that again?
Yes.
Often, don't they?
Sometimes, yes.
In fact, I would say some of the better attorneys know very well about therapeutic issues, because you have to argue them. Yes, Mr. Ross, or not?
I don't know what you understand, sir. I can't speak for you.
If you deal with, what is a borderline personality disorder, Mr. Ross?
He's not a doctor, and that's not an issue before this court.
Okay, let's go back there on your bill still. No, we got an answer.
Your Honor.
You are another
The
telephone.
comments you have to describe after comments.
527, Attorney Walker, discharge and withdrawal. That's you, right, Mr. Ross? LJR, 527.
Hang on just a minute.
Who is
Yes.
527.
Correct.
This one from Mr. Walker. Remember what that was about?
Yeah, I called him to say that we were discharged and we were withdrawing from the case.
Mr. Walker is my private attorney. Again, is there a reason why you're speaking to him here?
Yes, because you asked us to get out. His office had referred you to us. There was a hearing coming up, and I thought it was
So
incumbent
he
upon
referred
me.
you there?
And I thought it was incumbent.
Walker knew from the beginning that he couldn't represent me, but he still wanted to make money. He put me up for bids. Who took it? Ross. Why? Because they were in financial difficulty, and he cut a deal with Ross that they both got paid.
On me to let Mr. Walker know that we were withdrawing at the earliest date. I thought that was the right thing to do for you and the right thing to do for him, and I did it.
Okay, Mr. Phillips. You know Mr. Phillips?
I do.
You do. Is he a good attorney?
Yes?
Mr. Walker a good attorney?
Yes?
If my wife owned 20% of Mortgage Specialists, which you were my attorney, so you know it's true. Is that correct?
The particulars, sir, about these other issues.
Well, this is the fill. My point being is, in the relationship with Walker, did you ever talk to him about the missing records?
I don't recall that I did.
He's a good attorney. Can you explain to me why Mr. Phillips was representing me, where he worked at Divine Millimat, and Divine Millimat was the principal attorney of mortgage specialist, meeting my wife and myself. Is that even possible? Well, relevance in how he spoke. Mr. Phillips is on the bill. Yes, he's on the bill. So I get Mr. Phillips was the previous attorney. Divine Millimat was my attorney, so there's no way Mr. Phillips, because of conflict of interest, should have been my attorney. Is that so?
Your Honor, it's not relevant to the case before the jury.
Sir, in the engagement letter, Mr. Phillips' name is there. There's a clear indication that he is becoming involved in your divorce case as a result of the conversation with Mr. Phillips. And that's the end of Mr. Phillips. You won't see Mr. Phillips' name throughout the film, the next 8 months.
Didn't answer that question, though.
What was the question? Was it right or wrong to have Phillips?
Well, you're the judge.
Okay, that's right.
It is wrong, isn't it?
No, it's not wrong.
Oh, we can have a conflict. He could represent mortgage specialist and sue my wife, who is the owner, part owner of the company. Is that true?
No, the issue here is what you were billed for, what work they did for you, okay? And whether or not you have to pay
They
them more
billed
money.
me for the meeting of Mr. Phillips and Mr. Ross.
And the explanation is in the engagement letter.
It wasn't my explanation. I asked a question. That's
You
all.
were billed for our time in obtaining your file, and getting the information from your
The
counsel.
point being is I should have never had
who
this
was
Phillips.
with you.
It was a setup, and they know.
Your Honor,
Disregard that also, it's not part of what we do.
The end of my answer is that I met with Mr. Phillips to get his file and understand the status of the case, because I was asked to take it over. I did that work for you, sir, not for Mr. Phillips.
Mrs. Wise, Miss Wise, was the attorney on with my wife and Mr. Colesville. Is that true?
Yes,
Do you know Miss Wise?
I do.
Friends?
Colleagues, not friends.
Never gone out to dinner with her?
I haven't.
Have you ever represented her?
No,
She ever represented you?
no.
Has Mr. Tober represented both of you?
I don't know whether he's represented or not.
Yes. Have you had discussions with Ms. Wise regarding this case?
Other than the fact that you sued her and it was thrown out, no.
So you had talked about it get thrown out. How did that happen? What was discussed? Who was the judge on the case?
not relevant.
He brought it up.
Yeah, this is.
I'm asking him a question on the question he brought up.
Sir, were you billed with anything with respect to the
Mrs.
discussion?
Wise was on the other side of this. So I was paying during this. It was missing therapist records. This is Mr. Ross saying, I don't know where they are. Is it possible Ms. Wise has them? Ms. Ross?
I don't know the answer to that question.
You don't know the answer. So it's possible that
She
the attorney
says,
didn't.
she has said that she doesn't. I don't know whether she does or not.
That's hearsay, isn't it, Your Honor?
You've asked me what my knowledge is.
Well, I'm just saying, he's only the past president of the New England Bar Association. He would know.
Your Honor,
The future one does.
Ask some direct questions about that.
Oh, I did. You had a conversation with Miss Wise, Attorney Wise, who represented my wife. When was that conversation, Mr. Ross?
Sometime in the last year.
Sometime in the last year. 3 months ago?
I don't know.
Well, I'm just asking, was it 12 months ago or 2 months ago? Which closer?
I don't know.
You don't recall? Okay. But you did speak to Miss Wise regarding the case, right?
I discussed with her that she had been sued, and that her
And you
case
said
had
get
been-
kicked out.
And her case had been dismissed.
Right.
And she asked me how this one was going. And I
Okay.
said it's still going.
Well, I'll keep that. Why did she get dismissed?
objection, Your Honor, relevant.
He brought up the dismissal.
I'm not.
This happened in
that's fine.
the conversation.
He brought it up, but it is not relevant to what these folks are being asked to do.
What was regarding the conversation? For instance,
I'm going to ask you to move on to another area, sir. That's not part of what we're talking about here.
oh, Ronnie Wise, the divorce attorney, for my wife.
Look, you have to ask, he's a fact witness, asking questions of which he...
I'm asking him the conversation that he had. He's telling me in the last year, 2 months, 12 months, he doesn't remember, but was regarding this case, so it's relevant. He said the case get kicked out might persuade you think. Did you tell them it was the statutes of limitations what I spoke about? Oh, we missed that.
Folks, they're going to be told exactly what the parameters are of the law. They're going to be told to disregard collateral matters such as statute of limitations.
I'm asking his, think again, Ms. Ross. Ms. Ross, you just had the conversation with Attorney Wise. I sued her and you and many others that got off to the statute of limitations. Did you talk about the statute of limitations with her in that conversation?
I'm going to ask you not to answer that question. You have to ask that question about these bills, sir. We've been at this now for 2 hours, and you're not making any...
Well, he had a conversation about my case with Ms. Wise.
And I'm just making the statement that it's my job.
What was said?
No.
What was discussed?
No, it's not relevant to the issues before this jury in this case. That's my ruling from which you can appeal.
We talked about that appeal now, didn't we?
Anything else about the bill you want to ask? Or are you done?
You know what, let me take a look at that, right? Mr. Kent. Did you?
I met with Mr. Tennant.
Did you have a conversation with Mr. Kent? I want you to remember, Mr. Kent, he got his instructions from Ross and Walker. And Walker continued giving him instructions. Remember the email that I showed you about mediation? Don't tell Mike and don't file it. That was from Alex Walker to Jim Ten. All they did was pass the baton. The plan was the same, we just changed the players.
I did.
What was said in that conversation? Was it one conversation?
I had one conversation with him about your divorce case.
Not more than that.
I don't think so. I think I billed you for the time that I spent with you.
Mr. Ten, at the time, when I had him, he was the president of our association too, right? Do you know that?
I don't know.
He was. Mr. Ten, you spoke to him. What did you speak to Mr. Ten about?
I brought him a copy of your file. I talked to him about the status of the case. Cedric and I were together there,
What did you say to him while I'm asking you?
and I told him that my expert for you was Dennis Stone.
Can you speak up, please?
That's what we talked about.
You talk.
I brought him up to date on your case. I
You
told him that Mr. Stone was an expert. He hadn't worked with Mr. Stone before. And we brought him your file.
Do you remember Mr. Stone?
Sure.
Remember that hearing when you came out? The last time we saw each other? Mr. Stone was there, wasn't he?
I believe he was.
Ms. Cedric?
Yes?
Ms. Beauregard?
Yes.
And myself?
Yes?
Did we all expect you to file that motion in a hearing? Every one of us?
No.
Well, did anyone tell me we were going into that hearing without filing a motion? How about yourself?
Are you referring to the motion to
To exclude Mr.
disqualify?
Dover?
That had been communicated previously.
Excuse me?
That had been communicated previously.
Yet, you didn't announce that to me till after the hearing. Isn't that so?
I don't think that's so.
Always right. In fact, when you announced it, it was with all those people in that hearing room. Do you remember what you said to me?
I don't.
You don't?
I don't.
Oh, let me remind you, maybe you can remember. He's a joke. He's my friend. And you walk right out the door.
I denied saying that, sir.
Oh, certain things I remember.
I would not have said.
Well, we have witnesses, so if they say that you said that, all four would be lying.
I don't know that. I'm telling you what I...
So you're telling the truth. Okay.
I'm telling, excuse me, I'm telling you what I remember.
So I wasn't told, expected the motion to be filed. Everybody else must have been pretty good actors in their room because they appear to be as shocked as me. Now, I'm sorry, what was his name again?
Mr. Stone?
Who?
Mr. Stone?
Stone. Do you remember what you said to me?
Objection.
Did you hear Mr. Stone? I'm asking you what you heard.
Again, just focus me in on now. What are we talking about?
Mr. Stone, the expert witness, I'm back in that little room that you said was ridiculous. It didn't tell me you weren't going to file and walk right out. I'm asking you, before you left, Mr. Stone said something. Do you remember what he said?
Objection, Your Honor.
I guess it's yes or no, but Mr. Ross, do you remember what he said?
I don't.
Okay.
Let me see it. I remember. Do you remember him saying that the computers were destroyed and that we would never see them?
I don't remember.
Do you remember that he said that he saw Sarah meeting with Mr. Tolbert while Mr. Tolbert was still defending you?
Your Honor,
Do
let's...
you remember that?
Objection, Your Honor. You're saying...
Mr. Stone's a witness. He
Well,
can...
bring him in and we'll have him. This is-
We just have him subpoenaed. I shall. But I'd like to have it hear from Mr. Ross
He has
first.
no memory of it. You've heard him say it.
Well, I haven't heard an answer. Did you? So you have no memory?
I don't recall that, no.
Don't recall. You're going to hear a lot of don't recalls.
Objection, Your Honor.
I think they know
All
that.
right. Thank you.
Yeah. Were you the president of the Bar Association of New Hampshire, Mr. Ross?
1985.
1985. What happened? Did Wiggin Nourie close down?
It did in February of 2012.
Why would you say it closed?
Objection, Your Honor.
Mr. President.
At the time that this happened, this is well years after you were in.
No, it wasn't that many years now. No, it wasn't
8,
really.
9, 10, 11, 40.
In fact, would you say, I'll make it more pertinent, would you say Divine Nomad was in financial distress? I'm not sorry, Wiggin Nourie was in financial distress? It's called motive. And Judge McHugh knew motive, which is why he stopped Ross there. They didn't want you to know that they were in financial difficulty. That's why they did it. What you're going to see is multiple articles regarding the subject that I said directly.
That is totally irrelevant.
Oh, no. Meaning overbilling for a company that was in dire straits. For instance,
You have evidence of that from some professional you can call.
besides they closed down, that's pretty good evidence. But it didn't close down. Do you know why they closed down?
Objection, Your Honor.
Did attorneys, all right, let me add it. Did attorneys leave the law firm because they heard what has happened in my case and no longer wanted to work in Wiggin Nourie?
He would not know any of that.
He's the head of Wiggin Nourie. How would you not know this? When they go to leave, they speak to him.
And they tell him the truth, right? Every single time.
I'm asking him, when they were leaving, one after another, what were they saying to you, Mr. Ross?
I'm gonna rule that is not, that subject matter is not part of this case at all.
Miss Sedgwick, when she left, did she have a discussion with you?
Don't answer the question. Any more about the bill, sir? Yeah. Can you redirect, Mr.
Very briefly, Your Honor, please, the court. Attorney Ross, 4 things. Number one, because I think it got broken up some, you just explain succinctly to the jury what work was done about this question about attorney over. Why was it done and what happened to the work?
It was brought to my attention that Mr. Gill wanted Mr. Tober thrown out of the case as his wife's lawyer. And he wanted a motion to disqualify and throw Tober off the case on the basis that Tober had represented me in the past and was my friend. It was my judgment as a lawyer and somebody in charge of the ethic and conflict reviews in my firm for years. But that was not a solid basis or a proper basis to file such a motion. And I had that reported to Mr. Gill through Ms. Sedgwick. Mr. Gill did not let go of that issue. And in order to be cautious about what I was doing, I had Ms. Sedgwick and Ms. Beauregard do independent research on that issue to see if there was case law out there that would support such a motion. They drafted a motion to disqualify based on what they had found. I read it, I looked at the cases, and I made professional judgment that it did not support what Mr. Gill wanted us to do, and that filing it would be frivolous, and I declined to file. I offered Mr. Gill the opportunity to use that work product and have it filed either by Mr. Walker and his firm, or by the firm in Boston that he said was also his lawyer, in the event that he wanted to pursue it. That motion was never filed.
My understanding, Mr. Gill wanted you and Wiggin Nourie to represent him, but he didn't want Attorney Tolbert to represent his wife.
He did not want Attorney Tolbert to stay in the case for Sarah Gill.
Second, I asked a lot of questions about mental health records of Dr. Broussard, and just complaint to jury who was Dr. Broussard.
Dr. Broussard was a psychologist in Massachusetts who had reportedly worked with Sarah Gill.
And in an overview fashion, what did you do in your firm on behalf of Mr. Gill to try to get those records, and where did it stand at the time you were discharged?
It happened, in my memory, is in two phases. In the fall, when we first got into the case, motions for his records were filed and a request for his deposition was made with the court. Ultimately, that deposition notice was canceled. That was renewed later in 2008, and we were discharged before that deposition was taken. And in the interim, at Mr. Gill's insistence, Darla Sedgwick prepared and filed with the Mass Board of Psychology a professional complaint against Dr. Broussard, alleging that he had intentionally or some other way destroyed records that were important in the case. Mr. Gill has maintained that those records were the silver bullet in this matter, but I don't know that that's so.
And where did it stand at the time you were discharged with respect to trying to nail this down?
I have to look at the invoice exactly, but my memory is that his deposition, we had an order for production of records and his deposition, and it was not done because we were discharged. In fact, I don't know that it was ever done after that.
Third thing, Mr. Gill brought up several times that the number of hours you spent each month on the case was somewhat limited. Can you explain to the jury why that was?
There's several reasons for that. First of all, Mr. Gill had a very good working relationship with Attorney Sedgwick. She was responsible for the majority of the work that was being done at that point. Her hourly rate when we started was $275. Mine was $375. It is my practice to try and put the lowest rate competent person to do the work that's necessary to do so the client doesn't get overbilled. I could have made a lot more money if I did all that work at $100 an hour more. They didn't, because that's not my practice.
The time that you spent on Mr. Gill's behalf, you had this point in time that you needed to request a hearing or some other activity that required for that.
It did. I mean, you'll see in some of the bills that there are conferences with me for which my time is not charged. But when we would go to court, I would bring with me the people who had done all the preparatory work, so that if there was an allegation that we did or didn't do something, the people who were actually involved in it could be there to answer to the court to say, yes, we did or no, we didn't, rather than my going through and learning those 8 boxes each time we had to go to court. And that was our practice. It still is.
Do you still have the both of the exhibits 1, 2, and 3?
I do.
Would you just look at exhibit 1 for a moment, please, sir, page 3 of
Could
the...
you speak up a little?
I'm sorry, Mr. Attorney Ross, if you look at exhibit 1, the agent matter, the fee agreement, page 3 in particular. Mr. Gill asked you several questions about did succeed by the time you were discharged in getting those Poseidon records and the motion and the work that you prepared by Attorney Tolbert. The motion was on 5. I just want to call your attention to the second paragraph on page 3 of the engagement letter. Attorney Ross, do you see that?
I do.
It says we have made and can make no guarantees with respect to the outcome of this case. Is that what it says?
Yes.
The basis of the bill each month was the hours spent on each professional in advancing and trying to advance Mr. Gill's case. Is that right?
That's right. What Mr. Gill purchased from Wiggin Nourie was the skill of his lawyers and their time. It's not ethical in a domestic relations case to charge a contingent fee. I don't have a practice of adding anything onto a bill for result. I have a limited amount of time available for clients, and I bill the time that I work.
Is there any effort, any action on the part of Wiggin in order to review billing contentious hours or any excessive hours for the work of Mr. Gill?
No.
Thank you, Your Honor.
Who's Dr. Akron?
Psychologist from Milwaukee, Wisconsin.
Beyond the scope of your record.
Now, the redirect, you have to limit your questions down to the 3 questions that he asked.
It's on the bill. I paid it. Remember how much I paid Mr. Ackerman?
Again, that's the, you're limited now, the way the procedure works is you have to only ask follow-up questions to what Mr. Hilliard asked. Just the areas that he was concerned.
That's your rules.
Does it say on, what does it say as far as fee agreement, right? So we sign a contract, together we refer to it, right?
Yes.
Does it say,
We signed the fee agreement, that's correct.
what does it say?
You want me to read it?
I promise to pay you, and what do you promise to do for me? Refer back to that.
To represent you when you're divorced.
There's only a few hours that you represented me in this whole thing.
You hired Wiggin Nourie, sir. I'm one of the lawyers in Wiggin Nourie who work for
You're
you.
the one that I hired. You were the president of Wiggin Nourie.
You hired my firm, which is very clearly set forth in this fee agreement.
Right. Ms. Sedgwick. The conversation you had when she left, you don't recall?
Your Honor, beyond the scope of your record.
Yeah, we covered it.
Okay.
Yeah. Your excuse me, Ross.
Thank you.
Might have any further evidence?
No, Your Honor. Thank you very much.
Mr. Gill, you have some evidence, right?
Excuse me?
You have some evidence.
It's true, I'm not an attorney. I'll do the best I can.
Do you want to call witnesses, or do you want to testify yourself?
Excuse me.
Do you want to, what do you want to do?
Well, how about, I'll let Mr. Hilliard question me?
Mr. Hilliard not his case, so if you want to bring to the attention any issues before the jury, you're required to testify yourself.
All the evidence with Donald Sedgwick and all the letters and all the information, you're saying I can't use that.
But
In closing, you will see the complete affidavit of Dallas Sedgwick, who was given in front of 3 attorneys, and you will know why Judge McHugh did not want this in.
I
I do.
Seated. We all know why you feel that you were improperly charged.
Improperly charged. It was improper the whole time. What did I get? You didn't get the therapist records. Did you see anything on those records about my children and me getting to see my daughter? You won't. Because the records went missing. Mr. Ross's last statement to me was your wife sue her attorneys? The reason why is because she knew that Ronnie Watts had the therapist records. So we had to get past statutes of limitations. 5 years. And the reason why Mr. Tober is in there is because they are friends. And if they're going to commit malpractice, you better hope your best friend's on the other side. And that's how it works.
Well, it's very hard for me to interpose objections during that.
Although I think he's finished making his statement, so are you done?
Let's go. Don't miss what happened here. I sure did. Did you hear how McHugh said, oh, I think he's done? Shut me up again. But what I didn't know, and you tell me if you know, that was my testimony. Everything. That was my evidence. Everything. Do you think he gave me those instructions? Watch what happens tomorrow morning.
He's ready for cross-examination.
Yeah, I'm going to give you a copy of exhibits 1, 2, and 3 to refer to. I'd ask you first to refer to exhibit number 1, sir. Would you please confirm for the jury that as your signature on page 3 of exhibit 1?
It's not. But we can move on.
It's not your signature.
100% it's not.
Whose is it?
You got me. I only have about 1,000 signatures over there. Match this one up with one of them.
So someone signed this document and forged your name to it in August of 2007?
I've never seen this document. And I guarantee you, you can't pull a signature that I've done, any one out of 1,000, that looks even close to that.
Would you look at page number 1, exhibit 1, please, sir?
Page 1. Yep.
This is a letter dated July 18, 2007, from Attorney Ross, addressed to you as personal and confidential at 69 Concord Road, Gary. Is that what it says?
Does say that.
Is that your address? Was that your address in 2007?
It's still my address.
Did you receive this letter?
No, not that I recall. And listen, you see that signature? You've got my signature on 1,000. Tell me if it's close. Yeah,
We
it's a
had a
good one.
sidebar conference just with Mr. Gilligan here as well.
Well, the last question was, he had not seen the document before, he said, never received it. Yeah, that's right. I did, yeah.
I was going backwards.
Would you like a copy of my driver's license, Mr. Hilliard, so you can match up the signature to find out we're not even in the right ballpark?
So, Mr. Gill, it is your testimony under oath that you did not receive the July 18, 2007 letter that we...
What I'm saying is, what you just showed me here, I've never signed. And the signature you're showing here, which could be clear to all the jurors, if you'd like to do multiple copies of my signature, to see if this is my signature.
Did you receive the letter?
I have no memory of this letter, and I'm telling you, that is a forgery. In fact, let me take a look. Just checking the signatures of the people who did sign it. because it looks like they used the same pen. And if you would have mailed it to me, then I wouldn't have it signed yet, would I? Would you like a copy of my driver's license to verify the signature?
I just want to confirm that you're denying under oath before this jury,
Under oath, I'm telling you, this is a forgery, flat out.
and you also deny receiving one.
Right, that I have any recall of receiving this. This would have been 7 years ago. But I'm telling you this, I did not sign this. So this fee agreement, so forth, is a forgery. Look at the, you know what, my business is checking forgeries. I run a mortgage company. And you know something? Take a look at the pen who wrote it and the pen there.
It's not your signature.
I think I made that clear, haven't
It was
I?
not signed on your behalf by,
Excuse me?
it was not signed on your behalf.
Absolutely not. Why would I? Doesn't it say they witnessed it?
The letter says, at the bottom, read, approved, and accepted. And there's a line for signature by Michael J. Gill, and the date.
Pretty clear to me, and that's not my signature.
Let me ask you to look at Exhibit 2 for a moment.
We all down with one?
For a moment. Exhibit 2. Mr. Gill, and I'm focused on page number 4. In the lower right-hand corner of page number 4. And the entry of July 30, 2007. See that one?
Yes?
It's an entry by DSS, which is Attorney Sedgwick, conference with Michael Gill and Attorney Ross.
I remember it clearly.
So you did attend a meeting with Attorneys Ross and Sedgwick on July 30, 2007. Is that
Wrong. I want me to explain it to you? I met with Mrs. Ross. We were in a conference room with all glass. Mr. Ross came by, knocked on the window, and called her out. The door opened, it didn't close quite, and what Mr. Ross said to her, don't get close, you know what we have to do. When she came back in, that was the beginning of me putting me very curious about what's going on. So was that meaning exactly? Ms. Sedgwick testified to that.
Objection to move to start the last portion of the answer, Your Honor. Mr. Gill, please also refer to page number 2. Again, Exhibit 2, which is the invoice.
Could you speak up again, Mr. Hilliard?
I'm sorry. Please refer to page number 2 within Exhibit 2, which is the invoices.
Right, so number 2 is the last month. It really wasn't that month, and just billed me for sending me the bill, which extended the bill process. But go ahead.
There's an entry on July 30, 2007 by LJR, which would be Mr. Ross, 1 hour conference with client. Do you see that?
Conference for client. Yeah, never happened.
Never.
I remember clearly. Do you remember, Mr. Ross?
Your Honor.
Now you're in the position of having me answer the question, not asking.
And the document we have is Exhibit 1, at least purports to have a signature by you on August 2, 2007, 3 days after July 30, 2007. Isn't that right?
What date are we looking at?
I'm comparing the entries in the bills.
I understand what you're doing. What
that
date?
say that there were conferences with you by Attorney Ross and Attorney Sedgwick on July 30, 2007.
We didn't have that. I testified to that. Mr. Ross and I spoke all of about less than an hour, the whole time.
3 days later, we have someone forging your signature to the engagement letter on August 2, 2007. Is that right, Mr. Gill?
Absolutely right. And I would like, Your Honor, to present as evidence number examples of my signatures.
You have to just answer the question.
Well, I am asking the question. I've asked it 10 times, the same thing. So it's not my signature, but I think it's important now to show evidence, we wanted to see evidence, that this isn't my signature, not even close.
Sir, you're a fact witness now. You just answer the question. You can't editorialize at this point.
I know, about
In
the
your
lawyer,
closing-
the witness.
In your closing statement, you can. Okay, but not.
And you're looking at page 2, please, of the invoices, Exhibit 2. It reflects that on July 31, Attorney Ross prepared and filed an appearance on your behalf in the divorce case, correct?
I do see that.
And you received a copy of that appearance from Attorney Ross in the mail when it was filed with the court, correct?
I don't recall, I don't know that.
Did you ever receive any copies from Wiggin Nourie of letters or pleadings or orders that were filed or received in your case?
Well, we have copies too. All I'm saying is the one that I saw, I didn't sign. Now, with preparation for Attorney Ross' appearance, did I get that in the mail? Letter? Maybe. I'm not disputing a letter from 7 years ago. I'm telling you, I didn't sign that agreement.
Attorney Ross testified here this afternoon that it was the practice of his firm in 2007 and 2008 to send a copy to the client of anything that went out or came in on the client's case. My question to you, sir, is did you receive from Wiggin Nourie on a regular basis copies of anything they filed on your behalf with the court or received from others on your behalf from the court or others?
Did I get mail and motions and so forth? I did. I'm not a lawyer, and I did get a lot of that in the mail. And I'm not saying work wasn't done, just not on my behalf. And I'm telling you that Mrs. Ross' signature here and my signature here is the same pen, and I didn't sign it. So where did that leave us?
Mr. Gill, looking now at Exhibit 2, I take it that you agree that you received monthly bills from Wiggin Nourie during the time that that firm was represented. Is that correct?
It was, and I stopped sending him with Dallas Sedgwick saying that Mr. Ross said, make it rain, and it was fraud to get through the statutes of limitations, and that's when I stopped paying.
The first piece, he got the bills on a monthly basis.
And in fact, Mr. Gill, these bills are under tab 2 or 2. These bills each month contain an itemization of the date, the activity, and the person who performed it, and the amount of time. Is that right?
Yes.
Did you review these bills when you received them?
No.
I take it then that you didn't review them, you didn't raise any questions or concerns about the activity or the time or the amount of the bill. Is that correct?
The amount of the bills I thought was excessive. Hundreds of thousands to get divorced, it turned out to 5 million, I thought was excessive. But what got me upset was when I found from Attorney Sedgwick that it was all fraud, and that he was bringing his friend in to play catch.
Move to strike the last part of the
Right.
message.
He didn't question.
And in fact, you paid, did you not, Mr. Gill, the August, September, October, November, December, January, February, March bills. Is that right?
Right, until I found out what Mrs. Sedgwick told me. And then I immediately moved Alice Walker for a malpractice case and into Boston for a malpractice case against Mr. Ross, and then terminated him.
So the answer, folks, is yes. Okay, next.
You received the bill for the work that Wiggin Nourie did on your behalf in April of 2008, sometime in the early or middle of May. Is that right?
I don't recall that, but I got a bill every month. It was,
And the bill for May, the bill in May for time in April is on page 79 of our materials.
your question?
You never paid that bill, did you?
Well, if you notice, that's the month that I found out. Miss Sedgwick told me what he was doing. She even also said, and put it under oath, that, or under statement, that it was all fabricated. All the bill was.
So the answer, sir, is you didn't pay the bill, right?
Right, that's why.
Okay.
I paid every other bill on time, my whole life.
Disregard anything else but the answer to the question.
Your testimony in the road that you paid every bill your whole life, except these two?
Oh, and Divine Millimax when I caught them. But outside of that, I pay all my bills on time.
What about the law firm of 10 and 10 that you hired after you fired Wiggin Nourie?
Right, and Divine. You're right, I filed them. And, just like you said, brought them into court. Listen, when we started playing catch with Mr. Ross, they brought in Mr. 10.
And what about the McLean law firm that you brought in?
I want to talk about the law firms, let's talk about those lawsuits, and then I get to talk about them.
You made a statement, you always pay your bills.
I do.
You didn't pay...
I don't pay on fraud and cheating. In fact, I own a mortgage company. It has to be impeccable. So the question should be, why now? Why them?
Is at least...
How about this? I did get to pay $5 million.
There's at least 4 law firms that you didn't pay their bills. Is that...
10 and 10, Divine, maybe Morris Mahoney, all of which we're suing, all of which offered me $40 million to settle, including him.
Okay.
Disregard all that. Again, he can only give you fact evidence, not some supposition.
It was Hilliard that brought this up, not me. He opened that door. I didn't sign anything with anybody regarding to keep my mouth shut about mediations. I'm telling you, including his own client, they offered me settlement offers, and you can see it in writing. Well, I have it in writing. Is that a fact?
No.
Your Honor, I got to disagree.
Come on, sir.
Your Honor,
He brought up these lawsuits. He brought up the law. I do my bills was fraud. That's why. So he needed an explanation. He's trying to set up that I'm lying. I'm trying to tell him that I'm not. He's trying to create something that doesn't exist. You brought up the law firms.
Your Honor, I approached the bench for the sole reason that the last thing he said was someone had made an offer of settlement, and he pointed
For an explanation.
to Mr. Ross as if to suggest that that is...
Don't tell anybody. It's on the internet. You can check it out.
Your Honor, I will represent to the court there has been no discussion with this gentleman on behalf of Wiggin Nourie about paying a nickel.
Mr. Hilliard just lied to the court. Not a nickel, huh? You're right. It was a lot more than a nickel.
Settlement, and
I have it in writing. You better not. I have it in writing that Wiggin Nourie is part of the settlement. Part of the settlement. So you better. That's the only issue you have, though?
that's what I came for, because at some point, Your Honor,
Bring it in. I'll bring it in.
the process, I know we have an intelligent, sophisticated, experienced jury,
This is about,
but at some point, the process gets so tainted.
You're right, at some point. I'm not sure we're there, but we may be close.
Thank you.
Ladies and gentlemen, the law in this state is, with respect to settlements or discussions about settlement, they're not admissible for evidence for juries to hear. You're here to hear the facts only. What these parties may or may not have discussed amongst themselves before they got here and decided to put their case before you to decide, that's all irrelevant.
But if it's in writing, Your Honor, on the internet, from them, is that...
Disregarded. Next question.
Your Honor, I'm just checking out things we've already covered. One final thing, Mr. Gill, you fired Wiggin Nourie in May of 2008, is that correct?
I don't know, your bill says that you're charging me from June. or August. So I'm not sure. Is that the end of May?
It's the end of May 2008, sir,
Okay. So yes, I did fire them.
and your divorce case was finally scheduled for trial in March of 2012. Is that right?
They settled the night before they went to go to trial.
In March
For a tenth of what I offered my wife.
Your Honor,
They settled the night before they went, go ahead.
in March of 2012, correct?
Right.
Thank you, sir. All I have.
Okay. Any other witnesses? Mr. Gill?
Not that I have here.
Come up again. Folks, I'm going to excuse you for today. There's some other issues we're going to deal with. No sense having you sit through them. So I'm going to excuse you for the day and ask you tomorrow at 10 o'clock, okay? And as you know, from past cases, it is impermissible for you to discuss any issue about this case, any testimony, any suggestions, any records, anything, until the case has been given to you. That's one thing. The other thing I remind you of, you can't seek to learn more about this case through the internet or any other source, okay? Keep your oath in mind, and we'll see you all tomorrow at 10 o'clock.
Please stand for the jury.
The record to reflect the fact that the jury is left the courtroom now. There's an issue with respect to a potential witness, Mr. Gill, was called, and the suggestion from plaintiff's counsel is that she has no relevant and personal knowledge with respect to any issue in this case. And she's here now, so why don't we get her, put her on the stand, and ask her what you want to ask her.
I want to talk to the jury. I was to have Sarah Gill at this point as a witness. They didn't know what she was going to testify. Was she going to maintain lying or not? They couldn't take a chance. McHugh ordered the jury out. And Hilliard wanted to hear from Sarah on the witness stand before the jury hit her, just in case she told the truth. They couldn't have that. So McHugh ruled that the jury cannot hear her. So I did not have her testify.
Yeah, you got to get past this hurdle first, me. If I find it relevant, they're going to hear it tomorrow.
How can it not be relevant?
Well, that's...
You didn't want to call it now.
They may hear her tomorrow, so don't worry, right? But I have to figure out whether or not she has relevant evidence that she's here now. I want to dispose of that issue today. Now, let me just make the...
I have a problem with this.
I said, here's the two doors. Door one is you can say to me, I'm not going to call her. They have not put her on their witness list. I will not let her testify, okay? But that means that
Door number two.
Or that means just to close door number one, that means that you cannot call her tomorrow.
Right.
She's done.
Right.
Okay. Door number two is, I'll hear her now, and if you can convince me that she has something personal and relevant to offer the jury, I'll order her back tomorrow to give that testimony.
So if you say no, they never hear it.
That's right.
Is there a three-door?
No, there's no three-door, but if you call her in and have her testify, then you have a record for your appeal.
I already had. So you're saying I only have those options? And I have to make that decision right now?
Right now.
I have 10 minutes.
You have 10 minutes? So what are you going to learn in 10 minutes that you don't know now?
Well,
You've thought about this before, obviously. You know this
right,
case.
now bringing her in after Walker spoke, after Tober spoke. I want them to incriminate themselves.
Well, they can still do that. What's her testimony going to do with any of that?
Well, not if she doesn't testify. You're saying this is testifying there. This doesn't impact the jury. The jury should hear what she has to say.
Okay, and they may. If she has something relevant to say, I'm going to let them. I'm not saying you can't call her. I'm just saying you got to put her on first to make sure that she only has relevant evidence.
On the grounds, I'm sorry, Ron?
Yeah, on the grounds that if you were an attorney, okay, I would ask you if there's any witness that is offered as a witness before a jury, the judges look at and what we call
Why is she different?
No, it's not different. Let me just, again, the setup is this. If there's a witness that is suggested by either party and they want to call, the other party has the right to request me to request, what we call an offer of proof.
I'm not going to call him. I'll have him speak to the feds instead. I'll have them lie on the witness stand.
Okay, so she's not off your, she's not on your witnesses, that's fine. She's not gonna be called as a witness, that's fine. The next question is, you have the expert for Maine tomorrow?
Yes.
Okay, what else do you have in terms of tomorrow?
I'm learning from today, I have the, Mr. Tober being notified for tomorrow,
Okay, now somebody's calling him?
right? I'm asking the court, we're going to be calling Mr. Tober?
Yes, but who's gonna
Ms.
notify?
Wise?
Who's gonna notify Mr. Tober?
My paralegal.
Okay.
Doing that right now.
Okay, Mr.
You hear that okay? What you just saw is a judge committing fraud. What he did was inform all our witnesses that it had to be a court order, that he would order their presence, not me asking them. I'm going to show you a subpoena, one after another, squashed by these attorneys. And McHugh, right here, right then, set us up for them not to come in, so we would have no witnesses.
Walking down the middle.
Mr. Walker's on Monday, first day.
Wednesday, you mean?
Wednesday, right. And tomorrow, the building expert will be the first witness.
Yeah, that's the gentleman.
And then we'll try to fit in Ms. Wise, Mr. Tober, Mr. Schroff, and I'd like to be able to get Jennifer Rasmussen tomorrow. Now, they've all been notified.
Okay, I'm leaving that with you, because they're your witnesses.
I'm on it.
And the first witness is gonna be the gentleman from Maine, the expert.
I already had the questions all written down.
Okay, good.
Yep.
All right, 10 o'clock tomorrow, very good. 10 o'clock, thank you.
All rise, please.
I went home after court thinking about that forgery. And why? And I figured it out. It was more of a release than a fee agreement. They knew from the very beginning they were going to commit fraud. That's why it's forged. And the forgery itself, a third grader could forge my signature, unfortunately. This wasn't even close. How could they even make such a mistake? You know why? It was the first document you would have had signed. They didn't know my signature. And then there was the insistence of the mailing. Why that? It's because he couldn't say that he saw me witness it. Because if it is a forgery, he would have been lying and he could have been trapped. These guys are pretty difficult to put in a corner. So he says he mails it. Are we to assume, now that we know it's a forgery, somebody went in my mailbox, took out that document, forged it, signed it, and mailed it back to him? They were in financial trouble. They couldn't take a chance for me to read this agreement and say, what the hell is this? That's why it was forged. And you know who forged it? And we have many figures proving it. It was Dollar Sedgwick herself. So they worked in conjunction together. In fact, if you look at the fee agreement, it refers to one other document. And we have that document. And guess what? That's the forgery too. By the same person, clearly. Well, then it hit me. They're going to have a mistrial. They can't keep going. I went to court this next morning, as you're looking at right now, knowing that they were going to kill this case right then and there. They had to shut us off, and that was it. Watch what happens.
The Honorable Court is in session.
Folks, we need it, please. Mr. Gill's going to call you next witness, please.
Well, I'm going to call myself, Your Honor, but I want to...
Well, you can't do that. You testified yesterday. You're done.
Well, no, I didn't testify. I was cross-examined.
You gave a statement first.
No, that wasn't a statement.
Well, I don't know what it was, but you were on the stand. You can't
Listen,
you can't
we
come
just
back.
presented a forged document yesterday. I did not testify. I did not. And it wasn't clear that you told me that I was testifying.
What?
Because that we would have had an issue. The first thing I want to do is testify to what Mr. Hilliard interviewed me about.
No, the way this works is you have one opportunity to take the stand. And Mr. Ross can't come back either, by the way. If he
Well, wait a
comes
minute,
back-
I didn't testify. I didn't make a statement. Mr. Hilliard asked me questions.
I swore,
I have to
I swore
bring
you in, I swore you in, and I said, tell them what you want to tell them, and you made a statement.
Well, you didn't tell me that was my statement. The statement was my testimony.
Who would you think it was? You already made an
A
open
statement. How about this, Mr. Gill? Your testimony. Mr. Hilliard cross-examined me. I would like to make this my evidence. Your Honor, he just presented a forged document that I can clearly prove was forgery. And then we can go on why they forged it. I never saw this document. I can make a statement now, Your Honor.
You can make a closing statement, I suppose. You have one more shot at them. You can make a
Oh,
closing
I'm telling you, I believe this is criminal. I believe you didn't make it very clear to me. It was this. Mr. Hilliard asked me a question. We only have two parts of evidence, the bills and that agreement. The signature is so far off in this agreement, it is comical. You know why? It's the first agreement I would have signed with them. They didn't know my signature. Why? You remember Mr. Ross testifying? We don't make any promises. I was a multi-millionaire. They were in a recession. They took that with the intent of making millions and not having me go after them. I never saw that document. Now, you want to know? He said that he mailed it.
Your Honor.
It was the same pen.
May we stop for a minute?
Yeah, go ahead. What's your position on this?
I object to everything that's going on, Your Honor. It's inappropriate, and I'd like to make a motion outside the presence of the jury.
Come up from that.
I want to tell you this, I want a order right now to have that document preserved. And I would like that document in the courtroom tomorrow. We're going to find out that Mr. Ross signed that document. And the reason why that was that they did what? That was done by the same pen. That document was in only one person's control. Wiggin Nourie. Who signed the document? He did. Want to bet that's his signature? So the first act in this whole divorce was fraud. Was forging my name because they knew they were going to rob us. It's that simple. The same pen signed the agreement. And you can see it's not mine. They never saw my signature. This whole, and the piece of evidence was the bill and this. They are trying to get Mr. Ross off on a mistrial right now. I want you to know that's what's going on because we caught them bold.
Come up for a minute.
And I want a preservation order on that agreement. That is the principal part of their evidence. And it's fraud, and it's forgery, and they know we can prove it.
What motion do you want to make?
I make a motion, Your Honor, that the court exercise its discretion in view of Mr. Gill's continued violation, disobeying, ignoring of your orders and admonitions, that this trial, particularly now, has become so tainted that the court should enter an order. The court has done this before in similar circumstances, relying on the Lily Pitts case in 160 New Hampshire, within your discretion, to dismiss his counterclaims.
Dismiss the claim. You presented a forgery in this court, and you know
You
it.
get it.
Just like I said they were going to do.
Sure.
They presented a forged document. I want that original here tomorrow. There is no way I signed it, and they know it signed it. I would like to present as evidence my signature on my passport and credit card. I'd like the jury to be able to match that up against the signature. Why not? They presented that as evidence. You kept me to a very narrow scope. Just numbers, just the numbers. They spent all that time on that agreement. See? We don't make any promises. Well, I promise you I didn't see it. And guess what? They do make promises. We'll get your kids back. Don't worry about it. You think they're going to say, hey, we don't know how many millions you're going to spend? The intent was to do this. I say we have an expert go over that signature, and we're going to find out it's Mr. Ross's signature. So we have a forged document by Mr. Ross. It was impossible for me to sign it. Why he said he mailed it? Because he can't say he saw me sign it, because that would be, if it was proven to be a forgery, that's why he said he had it mailed. This is as simple gets.
May the record reflect that Mr. Gill is speaking out loud in presence of the jury, not at sidebar proof.
And let's make it clear that you're trying to get a dismissal on this, on that case, which is what I said from the very beginning.
I'm going to issue a long order in this case, having in mind what's happened over the past couple of days, but I am going to dismiss this litigation. You receive a long order, and then you can appeal it.
So you did this. Didn't I call it? From one. I hope you guys watch this video. This is a very big fish, and they can't have all eyes closed. That's exactly what I said was going to happen. You witnessed the truth today. Look at that video and tell me. Find out if the judge isn't included too. I'm just going to ask you for a few moments of your time. I want you to read through and look through the statement that Dollar Sedgwick made in front of 3 attorneys and myself, in writing. And you're going to see them one at a time. Please read them. And I want to show you another document. See, they don't want to tell you how many times they were involved in malpractice. In 2010, they were in a case of federal fraud. Now, in closing, I want to have you, just one sentence that Dollar Sedgwick put in a letter. It would be much easier for me to walk away altogether and done with this entire mess. But I want to expose them and what has gone on. I feel obligated to do so. This impacted me too. This fraud affects all of us. Please do not miss the importance of who these people are. Your U.S. attorney calls John Ross his mentor. Judge LaPlante calls him his mentor. Hilliard is the president of the New England Bar Association. These are the big guys. You just saw them. You saw the Judge McHugh, which I said up front was corrupt. You tell me if you see Judge McHugh differently, and he's not corrupt.
It would be much easier for me to walk away altogether and be done with the entire mess, but I want to expose what has gone on. I feel obligated to do so. I learned that Steve Tober would be adverse counsel. I knew Tober as he represented Wiggin and Nourie and had even represented me personally on a sensitive matter. I also knew that Tober was very close to Ross, that the two were good friends, and that Tober had previously represented Ross. From the time Tober first appeared in the case, his litigation tactics were extremely aggressive. Tober took a scorched earth approach. Tober's approach would be to excessively bill the divorce case, all of which would unnecessarily lead to increased legal fees for Gill and depletion of the marital estate. Eventually, it would become clear to me that the goal of Ross and Tober collectively was to extract considerable legal fees out of a once sizable marital estate. In December 2007, Gill became uneasy with Ross as his attorney. I recall numerous telephone calls and in-person conversations with Gill, where he informed me that he was not comfortable with Ross as his attorney. I told Ross early on that there was a conflict of interest given the aforementioned legal representations and relationships. I then directed an associate, Megan Beauregard, to perform legal research on the ethical issues involving conflicts of interest. Following our research, I concluded that a material conflict of interest existed and that we needed to disclose the same to the client. At the time, I did not know, but would soon learn from my associate conducting the legal research, that Ross, too, had been represented by Tober in cases involving ethical and legal malpractice violations. Given the above, I prepared a motion to disqualify Tober as attorney for Mr. Gill's wife in the divorce. The basis of the motion was the aforementioned conflicts of interest, the overall impropriety, and the potential significant compromise of the client's interests in a hotly contested divorce. I had countless discussions with Ross regarding the issues of the conflicts and argued strenuously that we move forward on the motion. On several occasions, I asked Ross why he would not permit me to simply talk to the client about the conflicts issues, especially since I had come to learn that Ross too had been represented by Tober. I could not understand why Ross was so insistent in his refusal to seek to disqualify Tober. I became so frustrated and distraught over these issues that I began to confide in several people close to me about the ethical dilemma. Specifically, I talked to Megan Beauregard, as well as my then current husband and even a relative, all with the single goal of trying to find out why a senior partner at my firm would block the disclosure of a conflict of interest. Up until this point in time, I had only the highest regard for Ross. I worked extremely hard on his cases and felt fortunate to work with him. Gill was unaware of the conflicts of interest relating to Tober's prior representation of me, Ross, and Wiggin Nourie. However, from the inception of Tober's involvement, Gill was uneasy with having Tober involved in the divorce because just prior to Tober's appearance, the records of a therapist, Dr. Broussard, went mysteriously missing while Gill's wife was represented by attorneys Rona Wise and Matthew Kozel. As I mentioned, in December of 2007, Gill became uneasy with Ross as his attorney. Gill expressed concern that a plan existed between Ross and Tober to bill the divorce case excessively. Gill was concerned that Ross did not want to have any contact with him. On numerous occasions, I continued to inform Ross that Gill was uneasy with Tober's involvement and was likewise uneasy with Ross's representation of him. I implored Ross to speak with Gill regarding Gill's concerns. However, Ross did not want to deal with the issue of whether a conflict existed by virtue of Tober's involvement, and Ross would not speak with Gill. In Ross's opinion, no conflicts of interest existed by virtue of Tober's involvement. Ross never discussed with me the subject of Tober's prior representation of him. Again, I could not understand why Ross seemed to be fighting not to move to disqualify Tober. During this time period, the global economic crisis had begun, and there were numerous in-firm discussions about rainmaking and billing clients. It became clear to me that I was being set up for something, and that if anything went wrong with the divorce, I would be blamed. Indeed, I knew that eventually the aforementioned conflicts of interest would lead to real problems with the client. I informed Tober of the motion, and it was clear that he was troubled by it. For example, at a court hearing following having advised Tober of the motion, Tober appeared to be trying to intimidate me by standing uncomfortably close to me, scowling, and generally looking threatening. I also began to realize that Ross's behavior in litigation style became unusual. For example, Ross informed me that if and when Sarah Gill's deposition would go forward, he would aggressively explore incidents of sexual abuse she suffered in her past. Doing so, however, would not advance the interest of Gill nor be relevant to any issues in the case. It was also out of Ross's character to engage in such lines of inquiry. It then became obvious to me that this line of inquiry would only be used to delay the litigation by forcing Tober to stop the deposition. Indeed, Ross was so committed to preventing the deposition of Sarah Gill in order to allow the extremely lucrative, approximately $100,000 per month case to continue, that he told me that Sarah Gill would never sit for a deposition. Ross said that either Ross or Tober would feign a heart attack or some other medical problem in order to stop the deposition. Ross told me multiple times that Sarah Gill's deposition was simply not going to happen. Meanwhile, it seemed as though every effort I made to advance the case was being thwarted. For example, I tried for many months to secure the deposition of the opposing party, Sarah Gill. Yet, when I would discuss this with Ross, he seemed unconcerned that we were unable to secure the deposition. Likewise, as discussed below, Ross was unconcerned and uninterested in the mysterious unavailability of Dr. Broussard's records. While Ross and I had worked closely together for years, there was now obviously sharp tension between us, and he was beginning to communicate less with me. I began to believe that Tober and Ross were in constant communication and were conspiring to frustrate the case from being advanced to closure. During this time frame, Wiggin Nourie's financial challenges became more acute. For example, there were no bonuses distributed at the end of 2008, and the litigation activity in the firm had declined precipitously. The firm had many meetings regarding its financial challenges and the economic slowdown generally in the legal profession during this economic recession. As the case continued, it became clear to me that anything concerning the case which I would tell Ross would soon be learned by Tober. I concluded that Ross was not representing the best interest of the client, but instead was acting in collaboration with Tober to continue the case and continue the sizable monthly legal fees being paid by Gill. Despite all the fees and my best efforts, depositions had been blocked or thwarted, and other depositions, such as Sarah Gill's, as noted above, surely would not take place under Ross's watch. I no longer trusted Ross. I stayed out of the office as much as possible. Occasionally, Ross would call me and inquire about the case. His most common question was to inquire about the client's current thinking. Through my conduct in the case, I began to make it clear to Ross that I would not be a party to what I saw as unethical conduct, and this created greater distance between me and Ross. Eventually, this friction was expressed in an email response that I had sent to Ross. He had asked me, in an email, to engage in some ethically questionable conduct, and I responded that I would not do it. By this point, I was close to leaving the firm. I did express to Ross the client's displeasure with the case, the lack of depositions, and other related issues. I informed Ross that the client wanted to interview other law firms. I soon interviewed William Levine of Lee & Levine in Boston, Massachusetts, as potential successor counsel to Wiggin Nourie. I explained to Levine that depositions had not been conducted, that discovery efforts were being thwarted by Tober without resistance from Ross, and that we had not obtained the therapy records of Sarah Gill. I said that I needed to find successor counsel who could properly represent Gill's interests. I also informed Levine about Ross's conflict given Tober's involvement and Ross's apparent efforts to force the expensive case to continue by delaying necessary proceedings among other things. They listened to what I had to say and agreed to a second meeting. After listening intently to the challenges I was facing in representing Gill, Levine advised me that the situation would not likely end well with Wiggin Nourie. He then gave me the name of another lawyer with an expertise in ethics. That lawyer, who also listened intently as to what I had to say, advised me to leave the law firm of Wiggin Nourie. As for the therapy records of Sarah Gill, they had been in custody of her therapist, Dr. Broussard. At various times, Dr. Broussard's office had represented that the records didn't exist due to 1, a water and flood problem, 2, a fire, and 3, an accidental shredding by Dr. Broussard's secretary. Broussard's office even stated that the records might be in storage. Ross rejected my efforts to challenge in court these suspect and inconsistent grounds for allegedly not having medical records. I came to the conclusion that Dr. Broussard's records may not, in fact, have been destroyed, given my review of the records of Dr. Garber, which note that he reviewed Dr. Broussard's records in which detail a conversation Dr. Garber had with Dr. Broussard, wherein Dr. Broussard acknowledges the existence of the records. From time to time, I had heard Ross make highly derogatory comments about Gill. This was unusual, as he typically did not make such comments about his own clients. Later in the case, as I began to understand what was happening between Ross and Tober, I reflected upon the fact that Ross strongly encouraged me to communicate with Tober by telephone rather than in writing, even insisting that I do so even though every phone conversation I had with Tober would subsequently be misrepresented by Tober, leading to follow-up letters, disputes, delay, and more legal fees. For this reason, I had long preferred to communicate with Tober in writing so as to eliminate such unnecessary work and delay. Ross never explained to me his rationale for why I should only communicate with Tober via telephone and not in writing. At some point toward the very end of my relationship with Wiggin Nourie, I told Ross that I know what's going on here. I recall making a statement along the lines of, "How much money do you need?" I gave my notice to Wiggin Nourie, advising them that I would be leaving the firm.